I'm ready for Christine Collins. Recognizing a quorum of commissioners in attendance, I call the October 29th, 2025 meeting of the Cannabis Control Commission to order. This meeting is being held hybrid pursuant to Chapter 2 of the Acts of 2025 and is being recorded. Commissioner Stebbins, Roy, and myself are participating in today's meeting. All votes taken today will be by roll call. We have a full agenda today that I will generally summarize. We will start with opening comments from commissioners. Before we proceed to commission discussion and votes, there are two items in the commission discussion and votes section today. The September 2023 through September 2025 public meeting votes discussion and discussion and review of draft regulations and policy questions for revisions to 935 CMR 500 and 935 501 regarding social consumption. I will ask the commissioners wishing to comment or ask questions during any part of the meeting, raise their hand to be recognized. So with those initial comments, I'll turn things over to Commissioner for any comments or updates. Why don't you start today, Commissioner Clay?
Good morning, Chair. Good morning, everyone. I'll be super duper brief. Just over the last couple of weeks, I've had the opportunity to speak at multiple cannabis conferences, one around compliance and banking, and the other one was the state of the cannabis industry. And I think it's great for commissioners to go out to these conferences, meet with stakeholders. The top three issues, obviously, access to capital, obviously federal prohibition plays a role in the lack of access to capital, and intoxicating hemp actually was the number one issue that people wanted to talk about. And so, it is an issue that is impacting our licensees. It is an issue that's being hotly debated nationwide. So it's good for us to get out and talk to folks directly. But I just wanted to share that. I thought that was some great insight that the number one issue was intoxicating hemp. So thank you for my time.
Thank you, Commissioner Stebbins.
Thank you, Chair. Question, the one of those you mentioned was that the PBC.
No, that's another one actually. So there's three that I've attended, and yeah, this one was compliance in Boston, and then the other one was state of the cannabis industry. I think it was like the 9th annual state of the cannabis industry in Boston. So and not only attended by folks locally and regionally, but nationally. And the number one issue is intoxicating hemp. Yeah.
Thank you for that. Just one update, Madam Chair. Yesterday, folks from our medical program and I had a chance to connect with Dr. Tischler, who's one of our certified physicians. He also happens to be a member of the CAB. Get some insights from him and feedback from him on, I think, a topic we'll be discussing today around the cooling down spaces and hearing his feedback. So that's it from me.
Thank you. And I had an opportunity to meet Dr. Tischler at a conference with a number of cannabis stakeholders at the Omni Seaport with Blank Rome. And a number of different issues were raised at that event. And by the way, one of the things I think Commissioner Roy and Executive Director Ahern, one of the things we were going back and forth with before we were actually able to speak is the issue of ethics. And this is one of the things that I hope we're going to have an opportunity to address in the coming months, making sure that we understand, given the fact that both the Inspector General and the Auditor have been highly critical of a number of our actions, but in particular, the Auditor making a statement that it appears that the Cannabis Control Commission had been engaged in disparate treatment of licensees, leading to potential concerns about favoritism. And so one of the conversations we were having, if you recall, is whether or not we needed to disclose if we're not taking anything, basically not even water. We have to be very, very careful about that. But it also sparked a conversation about making sure that not only are our commissioners abiding by ethics rules, but we have to make sure that all of our employees are stringently doing that as well, especially people on the front line who have significant power to determine the fate of our licensees or cost them tens, if not hundreds of thousands of dollars. So I think that a more robust conversation of what we require in terms of disclosure for all of our employees, commissioners, we're very heightened in terms of the commissioners and the role that we play and the ethics disclosures that we have to file. But I think it's really appropriate, especially, in dealing with some of those frontline people who are can make or break a business can suspend the license of a business or can do a number of different things to have that impact. And so just to begin, I'm just going to read our enhanced code of ethics for the CCC. And this is in regards to nepotism and financial interest. A, no commissioner or employee may participate in a particular matter as defined by General Laws, Chapter 268A, Section 1, that affects the financial interest of a relative within the third degree of consanguinity. Romanet 1, Romanet 2, a person with whom such commissioner or employee has a significant relationship as defined below. Or Romanet 3, a business organization in which he or she serves as an officer, director, trustee, partner, or employee. Or Romanet 4, any person or organization with whom he or she is negotiating or has any arrangement concerning prospective employment. Participate means participate in agency action or in a particular matter personally and substantially as a state employee through approval, disapproval, decision, recommendation, the rendering of advice, investigation, or otherwise. The financial interest must be direct and immediate or reasonably foreseeable. It cannot be remote or speculative. Where such a particular matter comes before any employee, the employee must recuse themselves from the matter and have a superior reassign the particular matter to another employee. Where such a particular matter comes before a commissioner, the commissioner must recuse themselves from the matter and, if applicable, have the recusal noted in the meeting. So anyway, in the minutes. So we'll have further conversations about how we have more consistent application of the ethics laws and disclosure, because I think that I also think that, and we've had this conversation, we also need to be looking at what our heightened code of ethics is and whether or not it still is relevant today. So I'm looking forward to that conversation as well. So anyway, I enjoyed my time at Blank Rome. We had a very good conversation, discussion, got a chance to actually talk to some social equity licensees who have an interest in the social consumption license, and they provided us with some excellent feedback about some of the things that we are talking about today. So we will be moving to September 2020. Oh,
quick question for you, if you don't mind. In Commissioner Roy, the conferences that you've recently attended, any feedback or discussion on the pending ballot initiative?
No.
No.
I brought it up, if I may.
Yep.
At the one I attended for Shields compliance, I'm on a panel. And I did bring it up because we talked about what's going on currently. We talked to, intoxicating hemp, all the current issues, and I brought up that there is a ballot measure, and people, most of the audience they were not aware. So that was news to them. Yeah.
Okay. So then taking up the commission discussion and votes, and as I stated when I returned from my illegal suspension and firing, I said that my sole compass will be to follow the statute, to follow the laws, and to make sure that we are doing that regularly. I will point out that I was suspended on September 14th at 5 o'clock, 2023. The night before, on September 13th, I submitted a duly executed, I designated Commissioner Roy to be the acting chair. She served as the acting chair in that September 14th, 2023 meeting. The subsequent meeting on September 18th, for some reason, the meeting was interrupted. It was declared that I had never sent a delegation letter. And then there were a series of votes that took place to vote in an acting chair, in spite of the fact that I had legally signed that letter of delegation. My case, Judge Gordon rendered whatever had happened to me in terms of suspension and firing was illegal. So all of the sort of subsequent appointments, votes, designations, whatever, are moot from the beginning. So what I am trying to do right now is to protect the commission. This may be an extra step that I think is appropriate and needed so that we tie everything up, because I would argue that from September 18th until I returned, we did not have a properly designated chair. So what I would like to do today is I would like to affirm all of the votes that happened when we were not properly organized under a legally designated chair under Chapter 10, Section 76H. page. So this is ultimately the belt and suspenders. We may never have anybody, any stakeholder sue us for a decision that may have happened while we were not appropriately organized. So what I'm trying to do is just making sure we're dotting our I's and crossing our T's, so that in the event that anyone is aggrieved by a decision that took place while we did not have a properly designated chair, we will say, no, we have now approved it. And so that's what I would like to do. There are Commissioner Roy?
Madam Chair, in your opinion, by doing this, does this protect the licensees in any way? Because since we voted on so many licenses, do you feel it's protective of
I believe that
their license?
I believe this protects the licensees from any sort of question about the validity of any actions that we took, and B, it protects the commission from any future potential lawsuits. So that's why we are doing this. And I am pulling out second. Attorney Ledzinski, I'm just trying to look, because there are just a handful of votes that Attorney Ledzinski, can you just help me find this? There are just a handful of votes that I believe that were taken that were not consistent with state statute. And so can you help me? I know that Jessica pulled those out.
Good morning.
Morning.
So the votes that you had pointed out were the September 2023 votes, where they voted in an acting chair instead of following the statute. And there was a June 2024 vote where they took authority away from the acting executive director. I vote.
In violation of the statute.
Of the 76, chapter 10, section 76. So there were actually 6 votes in total. I believe I sent you the dates of and Jessica Porter from the government affairs group actually did a lot of great work in putting everything together. So there were 6 votes that were taken. 2 were on the same day in September 2023, and the rest were either in September, December, or they went through June of 2024.
Could you please share those, what Jessica has pulled together? Could you share that with my fellow commissioners in the chat so that they can see that?
Yes, I will send teams. I'll send it to them right now.
Okay.
I believe she put it on board effect,
Okay, fine. All right, thank you.
so you could access it through there.
Okay.
And that is, it's still in draft because I haven't fully reviewed it, but we put draft form, but she did a great job in putting everything together.
So what we can do is we can address those things at a later time, but what I want to do here is just to make sure that we reaffirm, we are not changing the vote in any way. We're only going to be basically affirming that all of those votes that took place during that time period, minus those 6 votes, we are affirming the legality, and we are now properly organized with a properly designated chair. So now we are properly organized to be able to approve that. So thank you. Any questions or comments from my fellow commissioners? Commissioner Stebbins.
Sure. Thank you, Chair. You know, I would be curious. I did go through the report, which was added to our board book last night. You said there are 6 meetings.
There are 6 votes. They're actually in 5 different days. I could share those exact days with you. Yeah, that's fine. I'll give you the list of, no problem.
Are you going to just grab that right now?
I'll bring him. Give me 1 second. I'll bring my computer.
Okay. And while he's doing that, why don't we have, well, no, we can wait. I was going to say tee up everybody to sit down, just watch it.
So there was one on 9/18/2023. There were two on 9/21/2023, one on 11/9/2023, one on 12/14/2023, one on 6/13/2024, and the last one was on August 14th, 2024.
So just to restate, these are basically votes that were taken to appoint an acting chair that were not consistent with our enabling statute, because under our enabling statute on September 13th, with the approval on September 13th of the general counsel for the state treasurer, I was told by my attorney that former general counsel, current judge, Sarah Kim, acknowledged that I, as chair, had the sole authority to designate an acting chair. So with the understanding and approval of the treasurer's general counsel, I sent that letter out. It was received in a timely fashion. It was acknowledged by our then acting general counsel. And so that is what we are looking at. It's basically votes that took place to vote on an acting chair after I had legally delegated that authority. Is that correct? Can you, Attorney Ledzinski?
That is correct,
Except for one. That is correct, except for the one vote that took place in June 13, 2024, which was regarding the authority of the acting executive director at the time.
Right, and just to clarify for people who are watching, they and I know that this is also, you know, one of the things that the executive director Hearn and I are trying to work on collaboratively to make sure that we understand what the chair's authority is with power to manage all administration and supervision over the commission, and the clearly defined statutory authority once we appoint an executive director. And that is the vote that was taken to inappropriately, in violation of the statute, contrary to the statute, we basically took away authority from the acting executive director. We only have the ability as commissioners to vote for an executive director and to remove an executive director. We don't have the ability as commissioners to tinker with the statute that clarifies. And frankly, you know, we have to work to make sure that we're strengthening executive director Hearn's authority. And that is one of the things I'm working with him to make sure that he is working in his lane to do what he's supposed to do, managing the day-to-day, and then I'm leading the sort of broader policy decisions and regulations. So Commissioner Roy, do you have a comment to make?
I just have a question. Can we just walk through these so one by one? You said the dates, but.
Okay.
Okay, so September 18th.
All right, let me get to it's on board effect. I don't know if you have access to it.
Yeah.
Right now. I'm happy to look at this. Right, so. So the first one is September 18th.
Sorry, what was that first day?
September 18th, 2023. And the approved motion was to appoint Commissioner Concepcion as the acting chair for the purposes of conducting the next 3 regulatory review and meetings as currently noticed.
Okay, if I may, Madam Chair.
Please.
So the next one, I believe, is September 21.
Correct. There were 2 on September 21, 2023.
Okay, and the issue here, if you could say.
The issue is that they, you know, here it says September 21, 2023 approved motions. The commission approved the motion to affirm September 18, 2023's vote designating Commissioner Concepcion as acting chair for the final regulations review period. That's the first one. The second one is the commission approved the motion to designate Commissioner Concepcion as acting chair through the meeting of the Cannabis Control Commission on November 9th.
I may.
Please.
So, and the next one is November 9th,
November 9th, 2023,
in the issue at November 9th meeting.
the November 9th meeting. Let's see. Here it says the commission approved the motion to designate Commissioner Concepcion as acting chair until the December 14th, 2023 public meeting, while furthering their governance work until the end of the year and revisiting the conversation and rotation of acting chair during the December meeting.
Okay, and then if I may, Madam Chair, is,
December 14th,
and the issue there,
December 14th, 2023. It says the commission approved the motion to appoint Commissioner Concepcion as the acting chair until a new nomination was made by the appointing authority.
okay.
And then we go to,
You can, you
Just go.
just continue.
Okay.
That's the-
I have the floor. Thank you. Okay, is the next one June 6th?
June 13th, 2024.
13th, okay. And the issue there?
That is the executive acting chair issue. So,
Acting Executive Director.
Sorry, what?
Is it,
Oh, the acting
correct,
executive director, when.
Yeah.
When they.
June 13th, 2024.
That,
Commit,
Could you please read that in its entirety, the issue that's listed here on this packet, please?
the commission approved the motion to direct acting executive director Hilton Creek to prioritize their chief people officer hiring and human resources duties until a new executive director is hired and onboarded, and to delegate the following responsibilities to the commission's chiefs to effectuate that purpose. The general counsel to oversee all legal issues affecting the commission, including but not limited to labor and employment, contracts and procurement, litigation and claims, public records, open meeting law, ethics and the promulgation of regulations. The chief of investigations and enforcement to oversee all matters related to investigations, compliance, enforcement and enforcement actions, and licensing matters otherwise delegated to the executive director. The chief financial and accounting officer to oversee and lead in budget preparation, spend planning, procurements, funding, books of account and accounting records. The chief technology and innovation officer to oversee all information technology, cybersecurity and internal control planning. The chief research officer to oversee all research activities mandated by statute consistent with the overall goal to support the work of the commission and be a leading cannabis research resource center. The chief communications officer to oversee all activities regarding traditional communications, digital and creative services, government affairs and equity programming and community outreach. In the event of an absence of a chief, the directors of the respective departments will have oversight of their individual business units and activities.
If I may.
Okay.
So the statute reads, the commission shall appoint an executive director. The executive director, and this is the enabling statute of the commission, chapter 10, section 76J. The commission shall appoint an executive director. The executive director shall serve at the pleasure of the commission, shall receive such salary as may be determined by the commission, and shall devote full time and attention to the duties of the office. The executive director shall be a person with skill and experience in management, shall be the executive and administrative head of the commission, and shall be responsible for administering and enforcing the law relative to the commission and to each administrative unit thereof. So does that mean every unit under the executive director, they're responsible for the administration of every unit thereof?
That means that there's one administrative head and executive head of the commission, which is the executive director. And in the statute, it also states that the acting executive director will function in the same role as the executive director.
The acting executive director shall have all,
Yeah.
not some of the powers, but all of the powers and duties of the executive director, and shall have similar qualifications. Again, have all of the powers, not some of the powers. So was that motion at odds with the statute?
It was because it took authorities away from the acting executive director at the time. And it was in contrary to the language of the statute.
So it's direct odds with the law.
Corrected.
Okay, thank you. And Okay, and then August 14th, if you could read the issue at odds there, please.
On August 14th, the commission approved the motion to nominate Commissioner Roy to serve as acting chair for the day's meeting and for the purpose of next Thursday's meeting in Great Barrington.
Right, and so the board did not have the authority to do that because it's not enumerated expressly in statute that the board can do that. There's only one way expressly enumerated in statute, correct?
Correct. There was voting to nominate an acting chair.
Yeah, so I should not have been acting chair that day based on that procedural move.
Correct. There was already a delegation made in September of 2023.
Now, may I ask, should commissioners ever vote on something where they have a financial interest?
I believe the chair, Madam Chair, just read out
Right.
the 268A rule on financial interest.
So my question is to the executive director. Do you know if the acting chair was compensated to be acting chair, Commissioner Concepcion? With the chair's
I
salary?
was posed that question this morning. I've asked the CPO to follow up on that. I don't know the answer to the question.
Was Commissioner Stebbins received the chair's compensation?
Commissioner Stebbins was adjusted to the chair salary within the last year. I'm also confirming the question on the other acting chair.
Okay, and so anyway, just sort of moving on, because I want to sort of keep it to just this vote and not sort of any cascading issues thereafter. I'm going to point out a couple of different things. One, I think we all recall in around August, September of 2023, where our former executive director appointed an acting executive director. He basically made our COO, Alyssa Stack, the acting executive director. Attorney Ledzinski, did our executive director have the authority under statute to appoint an acting executive director? Who has the authority to appoint an acting executive director? Does the executive director have the authority to appoint an acting executive director, or is that retained only for the commissioners to do?
For the commissioners. That's why we went through a very involved process for executive director and also the acting executive director.
So I'm also going to remind people that what happened during that time frame is that Alyssa Stack, because she was not properly appointed as the acting executive director, the controller made us do what I'm asking us to do today, which is basically resubmit paperwork so that we complied with the law. We had submitted the paperwork already, but because it wasn't statutorily sound and it was submitted by someone who didn't have the legal authority to do so, we had to approve it. That's what I'm trying to do here. And then finally, I'm just going to make a point that when I was originally asked to be the chair of the Cannabis Control Commission, it was explained, I had actually asked, I would like to start on October 1st. And I was told, no, can't start on October 1st because, and I'm going to just visually explain to people how this chairmanship happens. Under the statute, there are 5 different commissioners, and each of us has a different seat that we sit in. And each of those seats has a term of office of 5 years. My seat ran from September 1st, 2022, or let's just back up. The seat that I was replacing was for former Chair Hoffman. And that was the seat that is for someone who's background in securities, finance, corporations. So what happens is under the statute, the term of the chair runs with the seat, not with a person, but with the seat. And you have to visualize this. There are 5 different buckets, if you will. And Treasurer Goldberg had said, I had said to her, why are you not going to be delegating the chairmanship to one of the other sitting commissioners? And she said, I'm making an affirmative decision to not delegate any of the people who during July 2022, when she first asked me to do this, she said, Commissioner Hoffman's term runs up on August 31st. On August 31st, the power baton, and I like to use it visually, it was in the seat that Commissioner Hoffman sat in. So what the treasurer did was she appointed Sarah Kim to be not an acting chair, not an acting commissioner. The term intermittent has been used. There's nothing defined in statute that says intermittent. The only reason it was called intermittent is because Attorney Kim was not planning on staying to be reappointed on September 1st. That happened for me. And I was told, no, you cannot start on October 2nd, because if you start on October 2nd, there won't be any way for us to delegate an acting chair. That is not in the law. So I had to scramble. I had to undo some of my business contacts. I had a lot of work to do in a few weeks to facilitate my appointment. So this is why I know that the treasurer's office understands the limited authority they have once an appointment is made, once the delegation of chair is made. So taking us back to what we did with the controller, we're not doing anything new. I am pulling out some of the votes that I think were inappropriate and did not comport with state statute. But what we're doing is exactly what we did with the controller. We're just dotting the i's, crossing the t's, and making sure that now that we are properly organized with a properly delegated chair and we have a quorum, that we're going to approve all of those votes that were taken when we didn't have a properly delegated designated chair. So with that, I don't know if there are any further, Commissioner Roy?
Yeah, Attorney Ladzinski, I just, before I vote, so the recommendation is to take the vote because some of these votes were at odds, directly at odds with the statute, with the law, correct?
These votes did not follow statutory
The ones that,
language, correct?
okay,
And I will even point out that one of the votes in there, that there were 3 votes to adopt the governance charter, which I have claimed and I have stated that when we began the governance process, this was always meant to be an agreement. And we were told from the beginning, it had to be unanimously adopted. It has not been unanimously adopted. The agreement was not fulfilled. So even that language, I do not support that. I would have voted against it because I think that there are some terms within that governance agreement that are not necessarily consistent with law. But as I believe it was Commissioner Concepcion said in one of our executive sessions, that it has no force of law. I am taking it as having no force of law, but I'm also saying that what is contained in there is not contrary. The vote itself was not contrary to state statute. So I will not question the wisdom of my fellow commissioners to have voted for it because the vote itself was consistent with state law. Commissioner Roy?
yeah, so if I may, I'm just trying to work this through in my head, real time live. So the recommendation for commissioners to vote on an acting chair, if a commissioner would have financial interests, how can those be reconciled? How can that scheme work? Which number one, I believe is contrary to statute. And number two, if a commissioner is to get a financial interest, how can commissioners then vote on an acting chair?
They recuse, under the law, they have to recuse themselves from that vote.
All right. I think that we've kind of, are you, Commissioner Stebbins, do you have any questions or concerns?
I do. Thank you, Chair. Help me understand. I haven't seen a motion yet, so maybe I'm a little bit ahead of myself here, but is the motion to approve all of the votes except these 6? And I guess what's the plan for addressing the minutes from those 6
I
meetings?
think that I think that the motion would be to confirm the legal validity of all of the votes that were taken during that time period, minus those, and then we will address those no later than the end of this calendar year. We will take a look at that.
But
What I'm saying is,
sorry.
I want us to confirm, I'm pulling these out because I have a duty and responsibility to make sure that the commission is complying with the law. There are many opinions that can be given, but my job is to be responsible for the administration and supervision of the commission. It's my job to make sure that we are acting in accordance with the statute. I have observed on multiple occasions, as a matter of fact, you probably know, that the Attorney General found that even though we had a legal opinion from both our former executive director and our former general counsel, we were meeting illegally in executive session to complete the discussions of the governance charter. So while we have many opinions about how we should be comporting ourselves, the one thing that I have done, rigorously looking at this, rigorously trying to understand, does this comport with statute? If it doesn't comport with statute, I can confirm it. So what I would like us to do, but I again, even in votes that I disagree with, even with votes that I disagree with, like the charter vote, it was duly taken. It wasn't done in violation of the statute. Only the votes that were taken in violation of state statute am I pulling out. But everything else will be affirmed, even if I don't agree. I don't agree with the yay vote on the governance charter, but I will assume that it was done reasonably, and I'm not going to get into the content. I'm only getting into the legality or illegality. I'm sure, Ray, did you have a question?
No, I think Commissioner Stebbins did on the motion language.
Okay, so well, I guess my question is, if we're finding fault with the designation of an acting chair in the meetings, primarily 9/18, 9/21, 11/9, 12/14, and 8/14, is that the last one? I know what 6/13 does.
8/14, yeah.
8/14. So we're questioning the selection of an acting chair. It would seem to me that all votes, if you're challenging that, all of our votes would essentially be viewed as.
What I'm saying is I am not challenging all the votes. I'm saying I think we need to see, someone has raised the term, are we unwinding what we did? Absolutely not, because they were never wound properly in the first place. So what I'm saying is I will not question the thinking or decision-making of the commissioners, whom I believe were inappropriately organized under acting chairs who were not properly designated as acting chairs. They were not designated chairs. There was one designated letter. It was ignored by my fellow commissioners. It was ignored by staff who intervened inappropriately in a meeting on September 18th to say that no delegation letter existed. That was not truthful. A delegation letter was there. I assume you received it, and you should have received it on September 13th, the night of. So my point is that I am saying that these votes need to be taken out because they, in and of themselves, are not legal. They did not comport with statute. Removing the authority of the executive director, and we also know that there was a violation of open meeting law when there was an offer made to someone else to be an acting chair, and that was also potentially in violation of open meeting law. So what I'm trying to do is wrap everything up, make sure that we're properly organized, and I'm not going to question any votes that you took or decisions that you made, but my job, just like what we had to do when we had an acting executive director appointed in violation of statute, the controller made us do exactly what I want us to do here today, which is just reconfirm all of the great decisions that you, Commissioner Roy, Commissioner Concepcion, Commissioner Margot, all of the decisions you made, save those votes, which I believe on their face were not consistent with our enabling statute. So it's basically a motion, just like we did with the controller. It's dotting the i's, crossing the t's, and making sure that we're comporting with the statute.
And thank you for that. And I guess what I'm still wrapping my head around is that if we're pulling some of these out because they relate to the designation of an acting chair, still wrapping my head around, how could we have called a meeting?
We could,
posted
that's
an
the whole
agenda?
point is it was not legal. That's the whole point. And that's why, just like, do you remember when, the former executive director appointed Alyssa Stack to be the acting executive director? Do you recall that?
I believe I do that recommendation. Right.
Do you recall what had to happen as a result of that inappropriate appointment?
I don't think the appointment ever materialized or effectuated.
Well, he did. He appointed her as acting executive director, and then she was filing paperwork. And then the controller's office reached out to the commission to say she is not, just like these meetings were not properly conducted under the authority of a properly delegated acting chair. So that's why the commission had to refile all of the paperwork that was inappropriately completed by someone who didn't have the authority. So what I'm trying to do is just like what we did with the controller, is we're finding all of those flawed meetings. And again, I'm not going to question whether or not your decision to vote on the charter was the right one or the wrong one. You were there, you made that decision. I may not agree with it. I should have been there to be able to vote, but I was illegally removed from my position to be able to vote. That being said, this isn't about me. This is about the soundness of how the commission operates. It's sending a message to our stakeholders. It's sending a message to consumers. It's sending a message to all public officials. We have a statute. It may be flawed. There may be some inconsistencies that we're going to have to fix, but the statute is clear. There is one way under the statute to delegate or designate an acting chair. It was appropriately done on September 13th, 2023, and then it was ignored. So what I want to do is all of the votes that were taken in my absence, I just want to make sure that we're not exposed and that the individual commissioners may not be exposed to any potential liability for having done something and not be properly organized. I don't know. I mean, I don't know if there's personal liability, but I will tell you, and I'm also going to bring back, this is not just a paperwork issue. When I was state treasurer, most people here are probably too young to remember the Big Dig. I know you're having a big birthday pretty soon. We're wishing you a happy birthday. But when I was treasurer, I had an issue that I had to deal with. I found out that the persons running the Big Dig and doing the financing for the Big Dig were not being truthful about the cost of the Big Dig, and that indeed they were well over $1 billion off. Now, one of my jobs then was, as the treasurer, I signed off on the bonds, and I had a meeting with the former secretary, and I said to him, I believe that you're not telling us the truth about the cost of the Big Dig. And I said to him, because you are not legally providing us with the due diligence we need, I am not going to sign off on the bonds next week. And what that could have constituted a significant problem, because multiple employees were not going to get paid if we didn't have the cash to do it. But it was making sure that we followed the law. I was adamant then, just like I strongly believe, we have to follow the law. We cannot be undermining the ability of the executive director to do his or her statutory job. It's not in our power or authority to do so. It's not in the power or authority of any of the appointing authorities to designate an acting chair. And I was told by the treasurer that the reason I had to start my job on September 1st rather than October 1st, 2022, which would have been way easier and more fun for me, is that we would not have been operating with a properly designated acting chair. So bringing it all back, I want to make sure that we're just dotting our I's and crossing our T's, making sure that we, just as we did with the controller, just as you approved back then, that we resubmit the paperwork so that we are following the law. Commissioner Roy?
Yeah. If I may, I'd just like to read a couple of paragraphs from the letter from the comptroller. And it says, based on this review, it is our opinion that during the period between September 11th, 2023 and October 16th, 2023, the CCC's Chief Operating Officer, Alyssa Stack, was not properly designated as Acting Executive Director. On September 11th, 2023, Executive Director Sean Collins electronically signed and submitted to CTR a key contact update form in which he designated Alyssa Stack as agency head. Collins signed the form as, quote, department agency head, and Stack signed as designee. Pursuant to the CCC's Enabling Act, however, the executive director and any acting executive director must be appointed by the commission, Massachusetts General Law, Chapter 10, Section 76J. Although the commission discussed during its September 14th, 2023 meeting, the fact that the executive director's authority had been delegated to other staff members, it did not vote to appoint any individual as acting executive director at that time. On October 11th, 2023, Stack electronically signed and submitted to the comptroller 2 key contact update forms in which she designated Daniel DuPont as Chief Fiscal Officer and Paul Clark as Internal Control Officer. Stack signed both forms as, quote, department agency head, end quote, and DuPont and Clark signed respectively as designee. Because Stack was not properly appointed as acting executive director, her attempt to designate these CCC employees as key contacts was without effect, and she did not have the authority to delegate those responsibilities. On October 13th, 2023, Stack electronically signed and submitted to the comptroller another key contact update form. This form designated Deborah Hilton Creek as agency head. Stack signed as department agency head, and Hilton Creek signed as designee. Although this form was not, and I'll repeat, legally operative, because Stack was not properly designated as acting executive director, and because even if she had been, she did not have authority to designate her successor to that role. And then it says the commission subsequently ratified this action. During an open meeting on October 16th, 2023, the commission voted unanimously to appoint Deborah Hilton Creek as acting executive director. This appointment was confirmed in an October 31st, 2023 letter to the comptroller from the acting chair of the commission. Also on October 31st, Hilton Creek signed and submitted to the comptroller a key contact listing form in which she designated Daniel DuPont as chief fiscal officer and Paul Clark as department security officer. She designated herself as internal control officer. Thank you.
So Commissioner Stebbins, any other questions?
Yes, Madam Chair. Question, a couple of questions, and thank you for the opportunity. I guess I raised a question specifically about the June 13th, 2024 vote. That vote delegation, for that delegation or direction to focus for the acting to prioritize her chief people officer responsibilities until such time as a new hire, new ED is hired and onboarded. Help me, or either Attorney Ledzinski, that delegation essentially now has gone away.
Well, thank you. So that goes to the authority that the executive director has under the statute. The statute says there is one head, administrative and executive of the commission, and that is the executive director. And, you know, this motion, in a way, reinterpreted the language of the statute to, here it says to prioritize their chief people officer hiring human resources duties, and then sent all the other administrative duties to the respective people that reported to her. So that's where it went against the language of the statute.
If I can clarify, it's just the vote itself. It's not when it, because we actually, one of the problems that we have been focusing on is the fact that we had established a budget of $100,000 for outside labor counsel, and that was tripled. And frankly, that budget was not appropriately should have been under the authority of the CPO, and that delegation basically cut her off from being able to do that in her actual role as CPO. And the executive director explained, well, since I've been appointed, that's disappeared. But the point is, it's not that the delegation remains illegal, it's that it was illegally adopted in the first place. So again, I'm just pointing out, if we could move on, I don't know if you have more questions, but I would love to be able to have the take the vote just as we did with the controller. I want to dot the i's, cross the t's. I don't need any legal opinion right now to know that these votes did not comply. They were not consistent with statute. They were not consistent with the opinions that I received, frankly, from the treasurer's then general counsel about how we appoint an acting chair. So with that, I'll entertain a motion. Commissioner Roy.
Do you have motion language we could put in the chat? Is there motion language that?
No, Commissioner Ray, can you draft?
We need 5 minutes, maybe we need a 5-minute break.
We'll take, all right. We'll
5-minute break.
All right, I'll entertain a motion to suspend for till 11:25. Do I hear a motion?
Well, it's 11.
Or 11:40.
Okay.
11:40. Commissioner Ray, do I have a motion?
So moved.
Do I hear a second, Commissioner Stebbins?
Second.
Moved and seconded. All in favor, say aye. All opposed, the ayes
Aye.
have it. So we'll take a 10-minute break.
Okay.
Calling the commission back to order. Commissioner Roy, you had one question before we hopefully can move on.
Yes.
You said, did you have another question?
Just my question was, I wanted time to look at in writing the motion language, which I want to thank the executive director, he placed in the chat. So that's helpful.
And Commissioner Stebbins, do you have any questions about the motion?
I do. I have a couple of questions. First of all, I think we got in the motion is drafted. I think there's you're not referring to the 8/14/2024, but the 6/13/2024 meeting regarding AED authority. And then I guess another question for Attorney Ledzinski doesn't have so much to do with the motion, but thinking through, I appreciate the thoughts of my colleagues, the concerns of my colleagues. I understand them kind of up until September of 2024, but I guess I'm asking, my appointment was also as an acting ED or acting chair, and wouldn't any of those meetings that I conducted necessarily not comply?
They are not, I'm just telling you, they're not, they were not consistent with my delegation. They conflicted with my delegation, and there is nothing in the statute. Again, as I began here, the treasurer's office told me that they did not have authority to designate an acting chair. The only authority they had was to designate a chair. And I believe from all the correspondence that I've seen, you were referenced as acting chair. Just like the vote to designate an acting chair was not done consistent with statute, so is that designation. So again, it's really just to make sure that all of this is done according to statute, because we had a legally designated acting chair as of September 13th, 2023, and that was ignored. So all of those votes afterwards, just like with the controller, when the former executive director appointed the COO to be the acting executive director, it was not done consistent, comporting with the statutory language. So that is why we are doing this, again, just to dot the i's and cross the t's to make sure that we are complying with the law, so that moving forward, we understand the statute, not irrelevant case law, not irrelevant how do other commissions work, but what does Chapter 10, Section 76 allow us to do? And that's why in looking at these and the work that has been done to point out all of those votes that were taken that were not consistent with my sole authority to delegate and designate an acting chair was ignored. So I don't know if you have any other questions, but I'd love to, Attorney Ledzinski, if you want to.
Yeah, the draft, thank you. So the draft of my draft of the language went to the chair because I had to get permission to get into the Board Effect chat, and I didn't before the meeting. So it states, I don't know if you want to read it, or this is my, so it states, I move to confirm all votes made in public meetings between 9/18/23 and 8/14/24, except for those made to vote for an acting chair on 9/18/23, 9/21/23, 11/9/23, 12/14/23, and 8/14/24, and on the ED's authority on 6/13/24. Do you want to copy it from yours? Okay, I'll send it to you. It's just that I'm not on the Board Effect. Okay, so.
You have high hopes, Executive Director.
Thank you, Madam Chair.
Okay.
Adding that in, I believe the only other thing I wanted to know,
there's
the comment earlier on the ethics question that Commissioner Roy mentioned. I'll work with you on to answer. I've certainly seen that instance in a variety of different public sector experiences where obviously this commission has been operating with 3 commissioners for a while. And so there's a variety of ways in which that question will be answered, but we'll follow up on that. And I'm putting this in the chat now.
I just did. I got access just now. Thank you.
So, good. So do you want me, so I will read this and I will entertain a motion to approve. Here's the motion. I move to confirm all votes made in public meetings between, wait a minute, I don't think the dates, you have 9/18/23. Up above, it says, 9/8/9. Yeah, I think the dates are not consistent.
If I may,
Through
Madam
nine- Yeah,
Chair,
please.
I
yeah.
think, so I had been looking at it based on the discussion that we were covering basically every meeting that you were not participating in, the last of which would have been September 11, 2025. So that's why I did all votes taken between those periods with the exception. So I believe with Associate General Counsel Lazinski's motion, if you just change it to that full period, that the rest of it then would work.
No, I don't think.
I don't think you need that.
Say, Commissioner Ray.
Yeah, so when I was handed the designation by the chair, I did chair that meeting on the 14th. So I don't think that's at odds with the statute.
That's the only one.
Yeah, and so I think that Attorney Lazinski's motion is more accurate in the sense that it's just confirming all votes. And also that anything else swept up in that day, licensing, everything is confirmed. You know, it's all confirmed. We're just extrapolating anything that was directly at odds with the enabling statute.
If I may, Madam Chair.
But hold on one second. Attorney Ladzinski, when I look at the 11:45 note, you have confirm all votes. It's from 9/18/23 through 8/14/24. I'm not sure that's.
That's the last vote that either a motion for an acting chair.
No. We're confirming all the votes between 9/18 and September 2025. We're confirming all of those votes.
You can edit that in the chat.
Okay, so
Saying
what I'm gonna, okay,
we're
so between 9/14/23,
9/18.
9/18, okay, hold on one second. So 9/18/23 and 9/11/25.
Yes. Yeah.
Okay, so I'm just gonna modify 3 letters,
You can edit it.
9/11/25. All right, I modified it.
All right.
Could you read it, please? Could someone read it into the record?
Okay. So the motion is I move to confirm all votes made in public meetings between 9/18/2023 and 9/11/2025, except for those made to vote for an acting chair on 9/18/2023, 9/21/2023, 11/9/2023, 12/14/2023, 2023 and 8/14/2024, and on the acting executive director's authority on 6/13/2024. I seek a motion to confirm.
So moved.
Do I hear a second?
Sorry, I won't second it. I have way too many concerns.
Are there any disclosures you'd like to make at this time?
Closures I would like to make at this time. But what?
Any potential conflict?
I just have, no, I mean, just reading the motion, I have concerns or questions about it.
I'll entertain any of your comments, any questions.
Sure. Again, I kind of come back to, reading the motion and again, the question about, the authority. Thinking through, again, the separating out of an acting chair vote.
We're not undermining any of the votes that were taken. We are just,
I just don't see how those don't cause tension between each other.
what doesn't cause tension?
Well, if we're saying that a vote for an acting chair, and subsequent to some of these votes, that acting chair.
All of the votes,
Meetings.
there was a, there,
posted
what the
agendas.
point is, I'm saying that these meetings were not properly convened. And so what I'm saying is that rather than leaving us exposed to potential liability, we can always defend, we could be sued and we could have to defend it. But what I'm trying to do is protect the commission, protect the integrity of how the commission operates, and basically say all of those votes that you took, save for those half dozen, that we're confirming the legality of those, that we are now saying, it's sort of like, I don't know, confession, when we're kind of saying, okay, this has been done right. It's like what we did with the controller. Do you remember what we had to do with the controller? Do you remember why we did what we did?
Right, because the authority we felt had been taken away from us by the, I believe.
Right, it was inappropriate delegation of authority. So again, we can even argue and we can take these out about those separate things. But what I'm just trying to do is make sure that everything that occurred after I delegated that authority, because I am the sole person under the statute who has that authority, I just want to, just as we did with the controller, I want to make sure that we confirm that all of those votes stand and have legal authority under the statute.
And I appreciate that, and I'm just trying to.
I can
figure out
explain.
how they're not disconnected. Another question,
Go
Chair.
ahead.
No.
I can try to explain something new to address your concern. So I think the goal here is just to make sure that no votes were taken that are directly contrary to the statute. That's it. So it was just regarding the acting chair delegation. Why? Because there's statutory language that says the chair makes a designation of the acting chair. That's it. Now, the only vote you're taking today is to confirm all of the other votes. So those specific votes that are being taken out of that confirmation pool, you're not talking about those right now. You're just confirming all those other votes that you took, except for those are not dealt with right now. So the question is, are you fine with confirming all the other votes except for those 6 that were taken during those 2-year period? That's really the only vote you're taking right now. The other, those six days are not being dealt with right now.
So, but if I may.
Please.
So if we're questioning, and I hear you, we're questioning the actual motions, the actual votes for that period of time in which we, as a body, elected an acting chair. I'm also struggling to see, when I was appointed acting chair, how all of those meetings also can be folded into this.
Like I said, I think it's because what the chair wants to make sure is that there's nothing that directly conflicts with the language of the statute, which pertains to just the acting chair delegation and the vote for that. So that's why the dates that I read out, the motions that I read out, were just regarding a motion to vote for an acting chair. So that's, and I don't think there was no motion to vote for you as an acting chair. So it's not, that issue is not even among these 6 situations.
I get that, but
Yeah.
so I guess I turn to the chair, and if you're arguing only you have the authority to appoint the acting chair, then my tenure as acting chair, is that valid?
I'm saying that there is one person who is validly delegated to be acting chair, and that was ignored. And that is my problem, is how do we deal with the fact that I think that it's my opinion. And if I'm wrong, taking these votes to affirm, even if your argument is that you were properly delegated that authority by the chair, which has been nullified by the court, by the treasurer, that appointment by the treasurer. Even if you and I disagree about the validity of your appointment,
It covers it.
It covers it. So all I'm trying to say is you and I may disagree about whether or not you are validly appointed. I don't see it in the statute. And again, when I first came and I first was appointed, I was told that I had to start my job on September 1st, 2022, because the treasurer acknowledged she did not have the authority to designate an acting chair. And I had to hustle to get into that job because otherwise the commission would have been without an acting chair because Sarah Kim did not want to be appointed to the next term. Now, again, she could have appointed her to that term. She could have designated Attorney Kim to do that, but sorry about that. Oops, sorry about that. I had it turned off. She could have done that, but she chose not to. And she told me, I don't have the authority to designate an acting chair. So again, even if we may not agree on the legality of your appointment, whether or not it comports with statute, I'm conjecturing it does not. You're conjecturing it does, right? So all I'm saying is that we can both be right, but I just want to make sure that if I'm right, that we don't leave ourselves open to a lawsuit. So Commissioner Wright, you had another point you wanted to, did you?
Yeah, no, I think you said what I was, it would cover the time that you were, the acting chair. It would cover those votes too.
If I may, Madam Chair,
Yep.
I think just also to that point as well, obviously, the chair and I spoke with the Attorney General. They weighed in to a certain extent.
Reclaiming my time. The fact is, I don't need an
Okay.
opinion right now of, I have not received any opinion from any other, and I made very clear that this is my sole authority and responsibility. And there is a possibility, as I believe you shared, was raised, that we could be sued. And so I am avoiding that opportunity for us to be sued. So again, I'm just, will you second that motion? Because again, it doesn't negate from your opinion, from your position. It just says we're dotting our i's and crossing our t's, just as we did with the controller.
If I may.
Please.
I'll tell you, I'm struggling with this kind of cherry picking out the votes, and I understand the reason why. I would certainly feel much more comfortable to the point you raised of confirming all of our votes, because taken between that time period, including the ones that are up for discussion and debate, because I just think you could kind of cherry pick those. But I do want to ask you, you did have a conversation with the Attorney General's office, and did they offer?
No,
lean in
No,
and
no,
offer?
there's no opinion, no opinion. I've received no opinion.
I'll second this for the purpose of voting.
All right. Having been moved and seconded, I'll take a call of the roll. Commissioner Stebbins?
No.
Commissioner Roy?
Aye.
O'Brien votes aye. So we do not have the requisite number of votes, and we will address this in the future. But thank you very much, and thanks for your indulgence and your time. Moving on to the regulatory writing process, and we'll now turn this over to Attorney Mike Baker. Are you leading this, or Attorney Bruno, are you leading this?
Madam Chair, if I may,
Please.
I'm happy to direct the board. We will begin with the remainder of the staff amendments from the last meeting that we were not able to finish. And so on the page guide, you'll note that we will be starting on page 107 under 500-141, additional requirements for social consumption establishments. We're in subsection 10, which is indoor smoking consumption area requirements. And I'll start reading at 500-141-10H.
Please, thank you.
And we read 141-10H as notwithstanding 935 CMR 500-141-10F. A social consumption establishment may submit an alternative ventilation and filtration plan prepared and certified by a Massachusetts licensed mechanical engineer that demonstrates protection of consumers and marijuana establishment agents at least equivalent to the requirements of 935 CMR 500-141-10F. The plan shall set forth performance criteria and proposed monitoring methods to demonstrate ongoing compliance with 935 CMR 500-141-10. The alternative ventilation and filtration plan is subject to receiving approval from the executive director. This amendment comes in part, as I discussed at the last meeting. There was a technical standard set under SOP section and a different technical standard set under the indoor smoking section. This provision pertaining to the alternate plan came from the written SOP section, so we brought it down to more appropriately the indoor smoking area. My understanding is that this was originally a consideration when there was a very high HEPA standard set that was financially very burdensome on potential licensees. And so this was somewhat of an intent, and correct me if I'm wrong, please, board members, to provide an alternative means for licensees to propose some other types of, whether it be technology or other type of ventilation and filtration plan that's sufficient to protect public health and safety. I know that we have discussed at the last meeting that there were changes to the ventilation and filtration requirements intended to try to lower those barriers to entry for the financial cost of that filtration program. And so this is a decision by the board whether you would like to continue to include the availability of an alternate plan and what that plan might look like. We had included the essentially a type of a seal certification from a Massachusetts licensed mechanical engineer, in part because in other sections of our regulations, particularly with cultivators, the regulations require certifications from similar licensed professionals. And that is kind of the gist of this particular amendment, it being moved and then also trying to mirror with some of the other sections.
Thank you. Are there any questions or concerns that my fellow commissioners have? Yeah, I think we have consensus here, or is there some?
Madam Chair, if I may, I do believe I&E had wished to present before the board on this particular.
Please, thank you, Armand, if you join us.
I believe in Madam Chair, Enforcement Council as well.
There you go.
Sorry. Would like to lead.
Madam Chair.
Thank you.
Thank you, Madam Chair. And thank you to the board on this. So from the Investigations and Enforcement Department, and I know that Chief Jones is out of office today, but
If I could just interrupt you and once again, congratulate. The reason that Chief Jones is not here is because she is receiving a very prestigious award at the State House today. So let us. For leadership and mentorship.
absolutely,
Yes.
absolutely. Thank you, Madam Chair. Just the particular piece that we wanted to note for consideration by the board here is this last sentence that identifies the alternative ventilation and filtration plan is subject to receiving approval from the executive director. So from our perspective here, and just kind of not to step into the shoes of the executive director, but just kind of illuminating a little bit of kind of process considerations here. We do think that so if we're talking about kind of any inspection or something along those lines, alternative plans, et cetera, those are generally, and I definitely invite Armin to speak in, or excuse me, Director Enos to speak on this as well, but that would typically have a kind of inspection that's associated with it, a report that's generated that provides a recommendation to the executive director. In this instance in particular, we don't really have expertise on our staff to assess whether any alternative ventilation systems are adequate to stand up to the same standards as are already identified in the regulations. So by requiring this approval from the executive director, and which would necessarily impact or create another process by which we would go through, inspect and approve, that could be just an unnecessary administrative burden for the licensees here. And also just recognizing that we don't necessarily have the expertise on staff currently to assess and provide that recommendation to the executive director.
Thank you, Commissioner Roy.
I move to strike the entire section based on that.
Thank you. Do I have a second?
Again, just give me a minute and read back through it.
Are we consenting or are we? Yeah, Director.
Thank you. I just want to follow up as well, because this was kind of the piece we're on at the end of last session here. So one of the things I brought up is what I would see from a building inspector on this is that often there is a request for an engineering stamp. One of the major concerns that we usually get from a business in that is that that's a cost to the business. So I think that the attempt here is to provide a little bit of flexibility, and yet within the comment period with the discussions of the commissioners to date, there has already been a bit of bending here in recognition of how significant that the previous HEPA requirement that was written was for businesses. And so going the MERV route was already sort of moving there. I don't mind the idea of allowing at some point in the future, maybe the commission does have the ability to review those types of alternate plans. But I think right now we'd certainly be in a position where we would not be prepared to. So I think that's really kind of the middle ground of where we are right now. And again, where the commissioners have already kind of taken the feedback from the industry, moved from the HEPA to the MERV, is already kind of meeting that need.
So Commissioner.
Again, I move to strike the entire section, and then someone could pursue the waiver process down the road if need be.
Commissioner Stebbins, are you comfortable with that?
Just a quick question, if I might, either for Enforcement Council. It's understanding the piece of it in giving some flexibility to our licensees. But you seem to be raising the point of Travis would need to go back to school to understand air filtration systems or getting his engineering degree. You're suggesting just striking out that last part where we're providing this requirement or this approval to the ED. I don't want to, I'm also mindful that I don't necessarily want to take away an opportunity for a licensee to approach us with a different plan.
But is this going to be, I mean, a lot of this, I think what we're saying is a lot of this is going to be at the local level, that we're going to be in essence empowering them to do what they already do and make sure that it is a streamlined process, that we are going to write guidelines so that we help municipalities flush this out in terms of what the state of the art is, but also not second guess, but to create that ability for the commission to make sure the boxes are checked without us having to get into, and Director, you're raising your, do you have a comment you'd like to make? Thank you.
Oh, yes. No, thank you, Madam Chair. Yes, as Enforcement Council said, again, I think, and as the Executive Director also said, I think one day down the road, as we kind of get our experience under our belt with this, we might present a day where we can handle this internally. But I think you absolutely hit it right on the head. The idea, I think, is to push this through municipalities as much as we can. As the Executive Director stated earlier, again, they are best positioned to be assessing these buildings. They do this all the time. They are familiar with this as well.
And they have staff, people on staff.
And they have people on staff as well. So
And tiny towns probably not going to be opting into this while we're alive, would be my sense, because there are some teeny tiny towns that don't have full-time staff, full-time, you know what I mean?
Yeah, I don't know if that's necessarily true. Teeny tiny towns may opt into this and they don't have the staff to.
So then tell me why I think I'm agreeing, but now I sound like I'm not agreeing.
I just heard from basically 3 people that we don't have capacity
We don't.
or expertise
Right.
on this. We've already compromised from the HEPA standard to a MERV. We've already made concessions. This is indoor smoking.
Yeah.
We've already made concessions based on feedback and cost and mindful of that. And now you're putting us in a position, this would be putting us in a position, and teeny tiny towns might not have the capacity.
Then I'm misunderstanding what I think we talked about yesterday. So maybe get me reoriented, because I think I am not necessarily following what Ione is saying and what you are saying. So reorient me, because I thought I understood this based on our conversation yesterday, but I think I missed it.
Sure, and Madam Chair, so I think from the INE perspective, what we are really highlighting is really just that last sentence. The rest of it, if the board wanted to allow for an alternative system that is signed off on by an engineer, I think we are not necessarily taking a position on that. It's the internal approval from the commission, similar to the conversation we had last week with commission-approved identification scanners. We don't have the expertise to identify what is an appropriate identification scanner, what is not an appropriate one. Using an industry standard would generally be satisfactory to us. In this instance, where the language does require that there is a plan that is prepared and certified by Massachusetts licensed mechanical engineer and demonstrates protection to consumers that is at least equivalent to the regulatory standard that we're setting, I think that would be something we were fine with. It is just us being an extra check on that. We don't necessarily have the expertise to check the engineer. So perhaps if the board wanted to still entertain this alternative option, perhaps that could be noted to the board at the time that the application is being approved. However, to Commissioner Roy's point, if the board also wanted to strike this and require that this is the standard, I think that would be something appropriate as well. I would say, as it relates to the waiver process, we might encounter some similar issues where my team reviews waiver requests. So we would really need to know what the alternative compensating features are. And I think in that situation, it's difficult to speculate or kind of forecast what our review would look like. Each one is identified or addressed on a case-by-case basis. However, in those instances, if it were me looking at that, I'm an attorney, I'm not a licensed engineer. I would be relying on the engineer in a lot of circumstances to understand what is the capacity of that alternative filtration system. Does it meet or at least provide an adequate substitute to what is regulatorily required? So I hope that helps to kind of address some of those questions.
So Commissioner Roy, how am I gaining? We don't have consensus. We will move on. And I would like to, when we get back together, I think I might need to take more time to understand what, but Attorney Baker, if you could just wait, maybe suss it out.
Sure, yeah. Happy to try to clarify here. So there is a standard that's MERV that we've discussed here. So that's adequate as far as the staff feels right now for indoor smoking to occur. There was a proposal from the working group through Commissioner Stebbins, who was leading it at the time, that they wanted an alternative to not bottleneck licensees if they come up with technology that is up to that standard as an alternative. So for instance, if there was like a personal device that could filter smoke. So again, we don't know what the technology will occur in the future. So we have alternative security plans similarly. And this idea was trying to kind of take that idea here where we have this standard, but if there's an alternative standard, it would go through the ED, again, to not bottleneck them. However, I think there's a bit of confusion here on these two pieces and how they interact together.
Yeah.
So I believe what Enforcement Council is saying is strike that exception. Is that correct? Strike that alternative plan?
Madam Chair.
Please, thank you.
I don't necessarily believe that we need to strike the entire one. My understanding from Chief Jones as well is primarily the approval from the executive director, which would then necessitate likely an additional creation of an additional process where our inspectors go out, perform an evaluation, perhaps speak with the engineer, speak with the licensee to provide that recommendation to the executive director. And that at this stage is potentially just an unnecessary administrative burden, and then also puts our staff in a position where they are acting outside of their expertise.
Please, Attorney Baker.
So in saying that, if this alternative is not good enough here and the standard isn't good for enforcement to review, then ultimately we do have this MERV standard that should be adequate. We're just not all offering an alternative again to not bottleneck licensees if they come up with new technology. So you can strike that alternative language and keep the standard here.
Commissioner, would you like to?
Yes, I have a question for EC Gooden. Do we currently do architectural reviews?
Madam Chair.
Please, thank you.
So I would actually prefer to defer over to Director Enos because that process is handled by the inspections.
So just a yes or no. Do we currently do architectural reviews?
Yes.
Do we currently, yes or no, have any architects and staff? Yes or no?
No.
Thank you. That's it.
So, Commissioner Stebbins?
Thank you, Madam Chair. And thank you to the EC and Director of Training and Deputy GC. And I think I share your concern of ED should not be in the middle of this process, if I'm hearing you correctly.
I'm not sure I'm hearing me correctly. This is where I'm getting very confused is can you just enunciate what you see as the optimum language here? We strike this. Is it that you don't think that that bottleneck should be there? Can you just share what your concern is? Because that's right. I just want to make sure.
I just asked
because I
if we
feel
do,
like
if I may, Madam Chair, I just asked Director Enos if the commission does architectural reviews. Yes, we do. I just asked Director Enos, do we have architects? Is it staff? No, we don't.
Right.
Okay, so, but we still do them, right?
Right.
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 And but here, the same logic doesn't apply?
I am not sure we should be doing the architectural reviews because
But we do them.
Yeah, I know. But all right, go ahead, Attorney Baker, and then.
Thank you. And I understand your sentiment here, Commissioner Roy. We have requirements for our delivery vehicles and we're not mechanics either. So I'm just putting that out there that's outside of our jurisdiction in so much as we are not inspecting the machinery, but we have to in some way regulate it so that it is performing up to the standard that we want to set here. And so we have to rely on, in this instance, mechanics for delivery vehicles, and then also an engineer in this instance to say that this HVAC system is adequate.
Hold on, Attorney Schroeder.
Thank you, Madam Chair. Just to try to level set the conversation, what is, I think, underlying some of this is if a person can't reasonably say no, do I have to ask them for permission? And in this case, and please correct me if I'm wrong, what INE is highlighting is that if there is an alternative plan that comes forward, a Massachusetts state engineer says, yep, this meets, let's say it even exceeds MERV 14 standard. This is great. I love it. I've got my stamp of approval on it. That ends up in front of the ED and the ED says no. Well, the next step, if I was working for that ME, would be, well, I'm going to sue and say that decision was arbitrary and capricious. What did you base that on? You have no education here. You just made it up. And I've got an engineer here telling me this is great. What do you have? And that feels like a hypothetical case that we would lose because we should lose. But in this, by removing the executive director from this, and again, please correct me if I'm wrong, is that it's saying that you've got the engineer that says this is good enough. And that would be good enough for us that, all right, you've got the engineer saying this meets or exceeds MERV 14. That's good enough for us. We say that's good under, you say it's good enough, we're going to agree with you, and this can go through the ordinary process.
Commissioner Wright.
Are we arbitrary and capricious when we review and approve or deny architectural reviews?
I would, of course, defer to Director Enos on that, but I also feel that the architectural reviews have a much more involved process than like second guessing an architect.
What if the standard was below MERV 14, but the inspector, the engineer says it's okay? then it undermines our regulations.
Again, the specific process, I personally have never done an architectural review, so I would defer to a person who's done many of them on that front.
Director Enos?
No, thank you, Madam Chair. Yeah, Commissioner Roy, to address your question, so our team does do architectural reviews, and as you asked, we do not have architects on our staff per se. However, I just want to give some additional context to the process. We are absolutely involved in municipality with that. So the building departments, law enforcement, if we need to reach out to them, they are consulted and actually part of the report that goes forward. If the recommendation does have set attribute what actions we're taking with the municipality to verify that. Now, obviously, we will do an on-site inspection on times to ensure compliance with our regulations. But kind of as we've been talking, it's a lot of the municipality that is doing that. It's attestations from an engineer. If they're building out their lighting envelope, we will have attestations from the engineer that they meet our horticultural lighting specifications. That is all information that we use as part of our due diligence, again, ensuring compliance with our regulations. But there is that reliance and that verification with the other experts per se that would be doing the work, building departments, again, the engineers. So I just wanted to add that additional context for the process.
Commissioner Roy?
And thank you, that makes my point. Because the local control provides attestations, but the commission is the final approval, which I have in emails that sometimes that costs money and delays for licensees for us to sign off on the architect. I literally have emails on that. And so basically what you're saying is what's in this language. We get the attestations from the experts, but the commission has the final approval, and it costs licensees currently money and time is money, we all know. And so that's this is being handled differently, special treatment versus architectural reviews.
Director Enos?
Thank you, Madam Chair. No, thank you, Commissioner Roy, for those points. I guess that the one additional thing I will say is you're absolutely right. Obviously, the commission kind of has that ultimate decision on the licensee's actions going forward. But again, I just want to stress the importance of, again, relying upon the municipalities, doing our verifications in the checks. As Attorney Schreffler kind of brought up in his example, you know, hypothetically, if we did come into a situation where an architect had a one position, again, not saying that that would always be the right position, but again, since we are not the experts on that, we.
But this point, I think that you're raising is about the making the process consistent.
That's part of my argument is making, and part of it is from a public health perspective too. I mean, I was the product of secondhand smoke. It's, you know, it's awful. Childhood illnesses. I mean, so I'm looking out for consumers and patients as well. I mean, if anyone that's lived in an environment where there's secondhand smoke, maybe you can't, unless you've been in those shoes, you don't understand those shoes.
Could we actually table this for a while? Because I would like to I thought that we had consensus. It appears we don't have consensus. And let's take some time, because I know I'm going to be meeting with the staff, and we can more fully vet this and make sure that we're keeping it consistent, but also making sure we're having the high standards of public health and safety. So
if I may, Madam Chair, and also consistency, and unless this applies to architectural review, I'm not comfortable with this, because that's a different application and it's not.
all right, I hear you, and let's move on and continue to gain consensus, and we can work this out. And this is part of the problem with only having 3 people here right now, that it gets a little bit harder to move this through. So anyway, moving on.
Madam Chair, if I may.
Thank you.
We will remain on page 107 and we'll move to the next subsection I.
Thank you.
And I will read this with number 1, and then we can continue to go through the subsections there as well. A social consumption establishment with an indoor smoking consumption area shall maintain and demonstrate ongoing compliance with 935 CMR 500-141-10. At a minimum, the licensee shall, 1, maintain records of ventilation and filtration system inspections and maintenance. I can continue on.
Please
Thank you.
continue. Yeah, Commissioner Roy?
Attorney Bruno, for how long?
That can be a decision of the board of how long the licensee should maintain those records. So that's certainly a policy choice as to the
Makes
length of.
sense that what might be consistent with other agencies. Do you have a thought on what you think that?
Well, we require with the videos, they have to, we have different requirements for maintaining records. So I think we need to be consistent, and this is too open-ended.
Commissioner Stebbins, do you have any questions, or that so can we make sure that that language is consistent with other parts of the statute in terms of record retention? Thank you. Good.
Sure.
Commissioner
Okay.
Stebbins?
I think Commissioner Roy brings up a good point. And I'm looking down to number 2, where they obtain certification of continued compliance from a Massachusetts licensed mechanical engineer not less than once every 12 months. So would we not want to at least say you have to maintain those records for 12 months so the licensed mechanical engineer can look at it and kind of, I'm assuming when the licensed mechanical engineer looks at it, he or she is giving it some clean bill of health. It's in good working order. It's got good filtration. It's doing its job. You're kind of good for the next year. So wouldn't they be able to get rid of all the documentation they wouldn't need the documentation from the previous year. So if you wanted to.
So what you're saying that because it says once every 12 months, it's only good?
No, what I'm saying is those records of inspections and maintenance, I could see holding those for a year because it seems every year you're going to get kind of a clean bill of health from that licensed mechanical engineer. So if we said maintain records of ventilation and filtration system inspections and maintenance for maybe go a little past the 12 months, like 16 months.
Does that,
Madam Chair, if I may.
I value just put on that.
Commissioner Stebbins did my job for me in reading the next line. So as far as kind of the combination of the two, I would suggest that that's certainly something reasonable if the board would like to adopt that. But I guess backing up, the certification of continued compliance is something for the board to consider if that's something you would like the licensee to continue to do annually. If that compliance check is something you would like to adopt.
I think that makes sense, especially when we're dealing with smoking, especially. So I think that language to that effect would be helpful unless you think this covers that. If you could make that, Commissioner Roy.
Did you recommend, Commissioner Stebbins, longer? You said 16 months?
I was going to say, thinking about number 1, and I'm assuming, Commissioner, you're worried about people keeping a lot of extra paperwork that as years go by, like, right, you can either, shred your tax returns after a certain period of time. But, maintain records of ventilation and filtration system inspections and maintenance.
With elevators.
I'm just trying to think of,
Well, no, I'm just saying,
Yeah.
in terms of maintaining.
the licensed mechanical engineer looking at your system every 12 months, I think is fine.
Mhm.
So maybe we think about the language as maintain records of ventilation, filtration system inspections and maintenance up through the annual certification of the Massachusetts licensed mechanical engineer. So that's, he or she has a chance to look at it. I'm all done with it. You don't need to keep it anymore. And I'm giving you the kind of clean bill of health going forward.
Does that make sense?
Yeah, I was just seeing if there was, to your point, if there was anything. I don't know if there's inspection rules that the state has that we're not aware of.
Madam Chair, if I may,
Please.
I'm not personally aware of inspection rules or the way municipalities might have those, maybe perhaps random inspections or annual inspections. I think it would be reasonable to adopt the language that Commissioner Stebbins has proposed, considering that you are going to now have a professional, a licensed professional. Their Massachusetts license is on the line when they're certifying these things. So I think that's reasonable if that's what the board would like to adopt.
I think that,
Yeah.
okay, do you have consensus on that?
Can we
Okay,
put that language in the chat?
Thank you for bearing with me.
thank you. No, it's on the fly. That's what it is.
Just spam. It's nothing but spam. Oh, you're a number with me. Ring Central. Not just ask me this, which is being the phone number. I don't use it, I just get spam.
Betsy is reminding me I'm fucking pizza and that's a lie. Sorry. I like living the town. I like living dollars. Thanks, Beth. Thanks.
Being
All
transparent.
right, so being transparent, we probably, all right, here we go, Erica. So we've got that language in here.
We might be able to work a little bit more on this, but I'll read it. Maintain records of ventilation and filtration system inspections and maintenance, and such records shall be maintained until the social consumption establishment has obtained an annual certification pursuant to 935 CMR 500-141-10I2, which is the annual certification site.
Annual, and it's good until. I think that language, does that meet your need to go beyond the 12 months, Commissioner Stebbins, or?
Madam Chair, if I can, I think you've tied it correctly. It's hold the data until the licensed engineer has a
Got it.
chance to look at it, and
Okay.
then you don't need to hold on to it anymore.
Good until it's, okay. Commissioner Wright, are you comfortable with that?
This may seem silly. Do we need the word all? After maintain?
All such records.
Yeah, Sure. Thank you.
Would you like me to put that?
You can edit it. Yeah, you can hit the thing.
Again, because we're not voting right now, I think that just to make sure, I just don't want to bog us down. So I think that we have consensus here, unless you would like her to.
She did it.
She did. Oh, great. Okay, fine.
Oh, no, not yet. Oh, and all such records. Yep, good.
Thank you.
Thank you.
All right, moving on. Thank you.
All right, if I may, Madam Chair. I am going to skip number 3 because that's related specifically to the alternative ventilation plan. And I will read 4, make all such records, certifications, and monitoring data available to the commission upon request. This was specifically a request from staff and licensing so that the annual certification documents and whatnot are available if there's an enforcement inspection or it's during the licensing process and the renewal.
Commissioner Roy?
Specifically, what record certifications and monitoring around the air filtration?
Madam Chair, if I may. Yes. Yes, Commissioner Roy, it would be related to specifically the indoor smoking consumption maintenance, but now that this is essentially a 12-month look back, I see how there may be some confusion with that subsection. So that's certainly something we can amend to include, try to work with the new language. If the board is comfortable with the maintenance of the records from, the last annual certification to the present, we can certainly amend that to reflect that period of time.
Commissioner Roy?
So this request came from who?
This was, I believe it was in licensing when we had a meeting with all of the departments where we were going through public comment and building out this indoor smoking section.
Okay, and it's not at odds with the proposal to strike in the previous section H because we don't have the expertise.
Madam Chair, if I may.
Thank you.
I don't think that there's anything at odds at that. It's just requiring the business to have the maintenance records on file. So if there is a system failure, those are things that I'm sure the commission would want to be aware of. And so it's a mechanism to allow the commission or its agents to view those documents if necessary.
Upon request.
Right.
Are you comfortable? Yeah. With that? Commissioner Stubbs? Okay, moving on. We're good.
Thank you, Madam Chair. We will go to J. Excuse me, on the same page. Social consumption establishments shall stop the consumption of marijuana or marijuana products in the indoor smoking consumption area if the ventilation or filtration system fails or stops functioning properly and until the filtration system is restored to its original approved and permitted functions. Any failure of the indoor smoking consumption area's filtration system shall be immediately reported to the commission, as well as the actions that will be taken to fix the filtration system. Combustion, heat, vaporization, and aerosolization of marijuana or marijuana products in an indoor smoking consumption area may not resume until the social consumption establishment provides notice to the commission that the ventilation or filtration system has been repaired and functioning properly. This was an amendment. It's actually very minimal to include because what we're talking about with these MERV standards and air changes per hour is not just filtration, it's also ventilation. So we included the term ventilate, essentially the phrase ventilation and filtration. So we added the term ventilation into that. We also added in the last sentence, combustion, heat, vaporization, and aerosolization of marijuana or marijuana products in an indoor smoking consumption area may not. The word not was unfortunately omitted. So very technical amendment there.
Okay. Thank you. Any questions? Commissioner Roy?
Thank you. My question is around consistency. We have immediately report. And then in other reporting requirements, it's 24 hours of such accident. Because the commission isn't open on a Saturday, Sunday, or at night, so how would one immediately report?
Director, Executive Director Ahern.
Thank you, Madam Chair. I believe, and I don't mean to cut off council who may be more technical on this, but I believe the discussion we had on this previously is that while we may not be here on a Friday night, for example, the expectation of the commission is that if they do not have operational ventilation and air handling, that they would be ceasing operations, so there's not smoking indoors. So that while it might be that we are not receiving that until a Monday, for example, that the expectation from the commissioners was that somebody that's aware of an issue with their ventilation system is notifying immediately. In terms of how it's written, I think, I'll turn that to council, but I think that's how I'm viewing this in terms of the expectation from us, to your earlier point on this being safe for folks in the room, is that if somebody's operating on a Friday or Saturday night, all of a sudden their air handling system goes in, that they understand that they need to cease operations until that's fixed. And that's what this section is speaking to in my mind.
Commissioner Roy?
And what is the mechanism to report?
I would ask for INE to come up and talk about all the ways in which we can do that. I think it would speak to our tip line discussion earlier, but there's a number of ways currently that you would get in touch with our INE.
Yeah.
So I think the question on the 24 hours would be, again, on a Friday night this happens, is it acceptable to the commissioners that we would be notified 24 hours later or immediately?
We could have INE folks just address that, because I think that your point about consistency, we already have a standard. Could you restate your question, Commissioner Ryan?
Sure. It's two questions. Consistency with other regulations that have a 24-hour reporting window. And also, what is the mechanism for reporting? Do they call their inspector's work cell phone? Do they email the general mailbox? Do they call the front desk and leave a voicemail for Kathleen?
If a fire truck showed up, if there was a fire, are you talking about that? Like, how do we, are you talking about?
No, I'm talking about this.
Saying in terms of consistency of reporting, are you saying consistency of reporting any sort of problems just as we have now, or am I missing that?
So if it's immediate, how do they immediately report? To whom do they immediately report?
Okay, all right.
And how? Who to whom and how?
Okay. I got it. I get what you're saying now.
If I may, Madam Chair.
Please, thank you.
Thank you. So Commissioner Roy, I just want to make sure I understand your question. So your question is, in the immediacy, if this happens, let's say a Friday weekend night, who is a licensee reporting to immediately?
Right.
Okay, well, per our incident reporting requirements, we would expect within 24 hours of any incident, they
Yes.
would be notifying their lead investigator.
Mhm.
And also per the regulations, they would have to follow up with a 10-day formal incident report that would have more detail in that. So within the first 24 hours, we would expect some notification, something happened, ventilation went down, window broke in, and the immediate steps that they would take in the moment to achieve compliance with our regulations. Within those 10 days, we would expect to, again, receive that more flushed out incident report that would have more detail, detailing what happened, ultimately what they are doing to fix it, if the problem would persist, and that would necessarily need further follow-up. As far as the formatting as that goes, really the requirement is, as long as they are meeting the requirements of that incident reporting regulation with that information in there, we kind of leave that up to the licensees regarding the form of how that actually appears. The most important thing is, did you tell us within 24 hours, and did you do the follow-up within the 10-day incidents? Now, I think your question about who else in the immediacy of that, I'll kind of defer to, enforcement counsel and the other members of the legal team, but I imagine there's going to have to be some kind of municipal outreach. I mean, they're going to have to call.
It says to the commission.
Yes, the commission. So, okay, yeah, I'm kind of talking about in gentle, but that would be the expectation. So your point is well received, but within 24 hours of any incident, we would expect that. Now, obviously, if these are submitted Friday night, Saturday night, Sunday, our staff likely would not see those until they sign on Monday. Obviously, then we would take necessary steps we need to take to follow up. Yes.
Mr. Stebbins and then Attorney Baker.
Thank you, Chair. Director Enos, from what you just said, should we not mirror some of the language or make reference to, or would it be a suggestion to make reference to our incident reporting requirements in this section? just to offer some clarity for our licensees.
Attorney Baker, I think you might already be answering that question.
Yeah, thank you. Part of this regulatory round, we had redrafted some provisions in incident reporting, specifically along the lines of public health and safety emergencies. Excuse me. And so that's a separate issue than what we're dealing with here. For this one,
Is it or mainly focused around telling them they have to cease operations immediately?
yes, exactly.
And because we don't have investigators running down on a Saturday night, if the ventilation goes out, we don't have that. We're not gonna have that.
Madam Chair.
Please.
Thank you. Part of the implementation discussion has been whether we want to require staff to have Saturday shifts. And so that's something that we would have to reconsider in light of this new license. So I've always assumed that that would be tackled in guidance and after the fact in the implementation working group. So we have had those discussions throughout the regulatory process here. And so that is my expectation after promulgation.
Yeah, I mean, just for consistency, and since you alluded to Attorney Baker, DGC, reporting requirements, number 2B2, marijuana establishment agents shall report to the commission and law enforcement authorities any vehicle accidents, diversion, inversion losses, or other reportable incidents that occur during transport not more than 24 hours. So I just for consistency, this says immediately, but how and to whom?
We don't.
And so now, does this air filtration have a more prescient lens to it? These are all around public safety, and we give them 24 hours. And we're saying you got to report immediately. So public safety can wait 24 hours, but the air filtration has to be immediate. And I still don't know to whom, how, and to whom.
Attorney Baker.
Thank you, Madam Chair, and thank you, Commissioner. We could say something along the lines of that to marry the timeline, no later than 24 hours for the HVAC notice to the commission.
Mm-hmm.
That's a fairly easy amendment.
Director Enos, I saw you nodding. Do you like that?
Thank you, Madam Chair. I was just actually gonna kind of agree with Attorney Baker there. I was looking at the incident reporting regulations and thinking, we could, because that regulation does say immediately and in no instance more than 24 hours following discovery of the breach or incident. So I think that might be a viable approach.
Okay, and Commissioner Stebbins?
Thank you, Madam Chair, and just picking up, I think, on your comment of should we break J apart? Because there's, what you pointed out is the system goes down, the activity stops.
That's right.
That should
The
be
two
one
thoughts.
section.
Yeah.
The next section should be something that follows our incident reporting requirements.
I think
Separate.
I think you
so. Can we give you that feedback, not have you do this on the fly? And then I think it would be appropriate to take a recess at this point in time. So are we good with that language? Does everybody feel comfortable with the conversation and what we just shared?
If I can recap, if I may.
Please, please.
So we're going to make a J and a K. And in one thought will be the one in J will be about stopping activities, consumption activities. And then K will address the reporting requirements, which will mirror the existing reporting requirements. Is that accurate?
I think we have consensus on that.
Okay.
Okay. And with that, I will entertain a motion to recess until, how about we say 1:25, which we will start 1:30, so until 1:25. And I think that looks like it should be enough to get us in and out. Okay, I'll entertain that motion. Commissioner Stebbins?
So moved.
Commissioner Roy? Second. Having been moved and seconded, all in favor, say aye. Aye. Opposed? We are recessing until 1:25. Calling the Cannabis Commission back to order, and we will turn it over to Attorney Bruno.
Thank you, Madam Chair. We will resume at page 51. And we are now under 500-103 licensure and renewal. We are looking at subsection 1I. And that reads, thank you, Madam Chair. And that reads, to demonstrate compliance with 935 CMR 500-14110, a social consumption establishment applicant that intends to include an indoor smoking consumption area shall also submit a ventilation and filtration compliance letter prepared by a Massachusetts licensed mechanical engineer with supporting documentation. This is, excuse me, a build out to include, of course, in the application process, essentially what the ventilation and filtration plan will be so that the licensing team can have that as part of their review.
Okay, any questions from my fellow commissioners? Hearing none, we will confer and move on.
And we will move to page 53 under,
Oh, Commissioner Wright, sorry.
Sorry about that. Thank you, Chair. My question is actually to the Executive Director. So in reading this, to demonstrate compliance with 500-14110, social consumption establishment applicant that intends to include an indoor smoking consumption area shall also submit a ventilation and filtration compliance letter prepared by Massachusetts licensed mechanical engineer with supporting documentation. I guess in our conversations, you had mentioned, or I think you said it about stamps and attestations. How is that different than a compliance letter?
I mean, Madam Chair,
Please, thank you, sorry.
I would view a compliance letter potentially as being a lower cost threshold for these businesses in engaging an engineer, not a no cost option. I think also it's possible that to be as efficient as possible in engaging a third party engineer on behalf of the business, they would want to be looking at what we are going to need as the CCC, what their locality, their municipality is going to need. And that this probably would encompass, they would summarize what they've received from their engineer. I would look at a compliance letter being a slightly lower threshold, potentially in certain instances than a stamp. So I think that answers your question, but.
Yeah, so I guess, and we all want to, just let me step back. We all want to see this license type succeed. But what I'm feeling is we're watering down things. And I don't want to compromise public health. And I feel because we want them, the staff, we all want them to succeed so badly that we're watering down things to the bare minimum. And because we're hearing cost. Well, yes, this is a costly endeavor. That's why I'd like to talk about other means of access to capital. So I'm feeling a theme of this going on because we all are cheering for these folks to do well, and therefore we're stamps and attestation a higher threshold.
I think that if we were to add, for example, filtration compliance letter that includes an attestation
Yes.
or engineering stamp,
Yes.
it would potentially in certain instances increase cost. Not always, but potentially. In certain
But
instances.
also it would a higher threshold around the public health ramifications, public safety. In other words, that it's a higher, you said it's a higher threshold of compliance, correct?
I would view it that way. I'd be happy to obviously turn it over to legal as well in terms of the language itself. But I think Attorney Bruno mentioned earlier that, these folks from an engineering perspective are putting, their professional integrity on the line and providing, whether it be stamps, attestations, compliance letters. So I think just kind of filtering out if compliance letter is undermining the attestation, I think would be something to talk through.
Okay, I'll leave it at that because I was going to ask you. Well, let me ask you this before we.
Please.
You overseeing a municipality, did you require stamps and attestations?
My building inspector in that instance, not because it was required from the state, but because it was required from how he was interpreting what was necessary under the CCC regulations, was saying to approve the HVAC system, he required
Stamps and
attestation, an attestation from a certified engineer.
Right, so I just had to express my uneasiness on we're lowering the floor or we're watering down because we all want them to do well. But we cannot compromise public health, safety and welfare while we're cheering these folks on. So I just had to express that. I'm feeling a theme here all morning of what's happening. Thank you.
Sometimes agree. So anyway, thank you. I appreciate that. Attorney Schroeder, did you have a point you wanted to make, or unless it's already been covered by the executive?
Only a minor point on this note. Some of this is also a nod towards, and I'm sure somebody from licensing would be a better voice on this. But when people apply for a provisional license, often those are preliminary plans, and those evolve before you get to the point of final licensure when you have your more finalized pieces. So, I mean, this is more it's more preliminary, and it's also another nod to the lack of certain core competencies. As we mentioned earlier, we don't keep architects on staff or civil engineers. We also don't maintain a doctor on staff to opine on certain medical issues. So the towns do have a bite at the apple here through the Board of Health process, especially where, hey, I'm opening a place where there's going to be smoking. The Board of Health is almost certainly going to have something to say about that and whatever standards the municipality wants. Just wanted to add that little note on this particular section.
Sure. I mean, we also can deal with some of this stuff, and this is, I hear you. And I know that you and I have differing views on some of these thresholds. But I also think that there are ways that we can deal with some of the stuff in guidance. I know you may not be comfortable with that, but Mr. Roy?
Thank you. I'm going to point to an example right around the corner. We have a indoor smoking lounge, Summit. We all know about it. What's their HVAC? It's all approved by the city. It's all local control and indoor smoking. And tell me how it's up to the city and they have a different lens than perhaps we do of what's clean air, public health and public. That's happening. We could walk there from here. So my point is local control is awesome, but I feel we're watering things down. And it might to a floor to make it easier. I get it, but I feel like we're compromising a little public health and safety because we have an example right around the corner where it's strictly under local control. I don't think they have all, just saying.
Attorney Bruno, I'm not forgetting names yet. Go ahead.
Thank you, Madam Chair. Commissioner Roy, I just wanted to explain kind of where this compliance letter language came from, and it's really about consistency with other requirements that we have for other licensees. So in that same subsection, under 1B, we have to demonstrate compliance with 935 CMR 500 12011, a marijuana cultivator applicant shall also submit an energy compliance letter prepared by a Massachusetts licensed professional engineer or Massachusetts licensed registered architect with supporting documentation. It continues on similarly for microbusiness or craft marijuana cooperative. And so I just wanted to kind of give that context as to where that's coming from. And I guess the goal was to keep the requirements consistent for these applicants. It's certainly up to the commission as a decision whether you would like something more to be required. If there's, of course, public health and safety concerns, that was just where the language was taken from.
Do you have additional thoughts that you'd like to raise the floor?
Yeah, well, I think the attestation or the stamp, this is a different animal, if you will. Versus an indoor cultivation. And quite frankly, there's legislation right now that's going to require us, if it gets codified, to check air quality moving forward. Right. That got out of the Senate. So, I mean, now cannabis dust is a recognized occupational hazard. That's kind of newer information. So they're not really apples to apples because of that.
Yeah.
So
So what would you feel comfortable?
Well, I think, Mr. Executive Director, if I may, you were going to recommend, I think, some language about an attestation or a stamp incorporated in there.
Madam Chair.
Please, thank you.
Thank you. I think that's one possibility, and I think to Attorney Bruno's point earlier, as long as we're being consistent here, where we're requesting sign off by an engineer, I think we want to be probably consistent throughout. I do think if we are clear that a compliance letter has is being signed off on by the engineer, it may be in certain instances, and we would want to obviously make sure, but it might be doing the same thing as the attestation, right? And so if that's what we're looking for to be consistent throughout is where I would be. In terms of the stamp and those types of things, I would anticipate that, what we're asking for is the engineer putting, their professional expertise to bear and their expertise behind what they're putting forward. So I would review the compliance letter language, ensure that it's meeting what you're looking for. And I think, I guess the other thing to the point that you've made is in a lot of these instances, not specific to this, but throughout our regs, we are creating the floor that municipalities can build off of. And so they are probably in no way prohibited from setting a higher bar. But I think to your point, so long as you as commissioners are comfortable that what we are requiring is meeting your public health and safety needs. So I think really just making sure that we are all clear on the definition of compliance letter is what I'll take away as next step here and report back.
Commissioner Wright?
What do we mean by supporting documentation?
Please, please, Attorney.
In part, in working with the other departments and in particular with licensing, my understanding, and if anybody in licensing has any other information, please correct me if I'm wrong. But my understanding was kind of the plans of the HVAC system, any schematics that might be included, essentially what it is visually, ventilation and filtration
So
plan.
would you say including but not limited to language there? Is that not necessary?
Oh, sorry, Madam Chair.
That's okay.
We certainly could. I think that it's something we could also explain through guidance, other supporting documentation, if there's anything that changes, if there's other technologies that might evolve. It's certainly up to the board if you would like to explicitly state the type of documentation you'd like to see. I think guidance could also cover that, so you have some options.
Commissioner Wright?
Is guidance enforceable?
I think, I understand that there's a difference between regulatory language and guidance documents, so your point is taken. I think that if there's.
So could I just interrupt? Maybe we have additional language
Yeah,
that says
just tighten it up a little.
Including but not limited to.
and then
That'll work.
Attorney Chocolate, I think that we just dealt with it, but. Okay, all right, thank you. Moving on again. I don't want to rush you on that. I just want to make sure. that you-
listening, my
Yeah, thanks.
Thank you so much.
Okay. All right, moving on. Attorney Bruno.
Yes, thank you. I'm just making notes so I don't lose
Sorry,
track.
no, take your time.
Updates. And we will move to page 53. And this is subsection 4, expiration and renewal of licensure. And this is subsection K. To the extent updates are required to the information provided for initial licensure, a social consumption establishment with an indoor smoking consumption area shall submit an updated ventilation and filtration compliance letter prepared by a Massachusetts licensed mechanical engineer with supporting documentation, together with a renewal application submitted under 935 CMR 500-103-4. And of course, we can take the comments from the last subsection and apply those here.
Thank you, Commissioner. Is that satisfactory to you? If you make that consistent with your last point? But not limited to, that just kind of clarifies the kind of documentation.
And this is under what section, Attorney Bruno? What's the headline of this?
This, if I may, Madam Chair,
Please.
this is expiration and renewal of licensure. So upon,
This scenario would be under a renewal.
yes.
The extent updates are required to the information provided for the initial license. So is it saying that to the extent that the commission updates are required by the commission? I guess I'm confused by this language.
If I may, Madam Chair.
Thank you.
I'm sorry, Attorney Scheffler.
Yeah, just a short point on this is functionally, we issue a new license every year, which it's a matter of administrative convenience that, hey, everything's the same from your first application. So if everything is the same, then you don't have to update us. It's the same identical information. This would be more along the lines of, hey, you changed something, I don't know, you added a vent or maybe you swapped out a filter somewhere. Well, you have to tell us that you have altered something from the original application, that it doesn't carry on forward.
So to that point, I don't think it's worded.
Okay. Attorney Stebbins, Commissioner Stebbins,
Attorney.
you like that?
No, I think to the point Commissioner Roy was also raising is that making it clear that if there's some type of difference, but I don't think that's defined appropriately in that first sentence.
Attorney Bruno?
Thank you, Madam Chair. This language is taken almost verbatim from subsection D, where we require in a similar nature for cultivators. So I'll read that, and I apologize for not briefing that previously when I was presenting that. Yes, thank you. So D reads, to the extent under the same subsection 4. To the extent updates are required to the information provided for initial licensure, the marijuana cultivator shall submit an updated energy compliance letter prepared by a Massachusetts licensed professional engineer or Massachusetts licensed registered architect with supporting documentation together with a renewal application submitted under 935 CMR 500-103-4. So that language was taken for consistency of how the regulations have already been in place. Certainly we can make those changes. I just thought it was important context.
Thank you. So just sort of getting back to your original question, Kim, Commissioner Roy, you were saying that you think that this needs to be reworded, or are you comfortable with what she is?
I think it is, I know you're saying for consistency, and I understand like why you would lift and shift it over here. That makes perfect sense. But I don't think it accomplishes so if I understand it right, so to the extent that the licensee makes any updates to the indoor smoking consumption area, they need to update us upon renewal is what. And this is saying that to the extent updates are required, the information provided for initial licensure, this is initial licensure. Shall submit an updated energy compliance letter. I don't think it's worded great there either, in all honesty.
So
we can leave it and then add the language that you had said, but not limited to.
Right. So again, in the interest of time, let's just move forward. You can note that and we can figure that out. Yep.
I'm here if I may.
Attorney Bruno, thank you.
For outdoor smoking consumption areas, in the interest of time, the amendments in that section are mirrored in regards to personal protective equipment that the board had already come to consensus for the same language in indoor smoking. And so if there's consensus for indoor smoking, does the board want to visit the language for outdoor smoking for PPE? It's the same exact ad that there be no retaliation taken against an agent who would like to wear PPE in an outdoor smoking environment. There was consensus on that at the last meeting. I think it would be appropriate. We could continue to move forward if you would like, Madam Chair.
I'm comfortable with that. Are you fellow commissioners comfortable? Commissioner Stebbins, Commissioner Wright? Okay, moving on. Thank you, Attorney Bruno.
Then we would move on to page 108, which is the cooling down areas.
Thank you.
All right, so we are looking at 500-141-12C, which reads, use of a cooling down area shall be a voluntary decision made by the consumer. This was an addition after significant public comment that the public wished for clarity that it be the choice of the consumer to utilize the consumption area as opposed to there being any, I'm sorry, yes. Oh, geez. Thank you. Yes, to the cooling down area, as opposed to a marijuana establishment agent being the decision maker in the process.
Commissioner Wright?
I move that we strike section 12.
Commissioner Stebbins, I know that this is something that you are very supportive of, but I will tell you, literally had a conversation the other day with a well-known social equity applicant who also owns a bar, and asked for their thoughts on the cooling down section. And the response that I got from them is, it does not make sense. We're asking people who are consuming an intoxicating product to self-regulate, self-police. And what this individual said to me is, what I want to do as a bar owner, which is what I would want to do as a cannabis bar owner, for lack of a better term, is to make sure that I got the patron safely home. That one of the suggestions is that depending on, and again, I don't know the difference between sativa and all that other stuff, differentiation, but stated that this could potentially create greater anxiety and negative response. So A, I don't know how we police it. B, I don't know whether we should put this on the patrons who are consuming an intoxicating substance to put themselves in a corner, whatever. I think that language that requires that we have access to water, access to shelf-stable food, access to things like that. But I don't know where this comes from. I don't know how it makes sense. And everyone that I've heard from as a stakeholder who said it just in theory, it sounds interesting, but in reality, I don't know how we police something like that. So I don't know where you got the language from. I am likely in agreement that I think this should be struck completely, but can you tell us where this came from and why you think this is a good idea? I appreciate it.
Sure. Thank you, Madam Chair. I believe the original idea, the original notion of making this available to a consumer came as a result of our colleagues' trip out to California. It wasn't anything I heard about in my visit to a dispensary in Colorado. But, you know, in thinking this through, and for some reason, this kind of came through for me recently, just thinking about a lot of the safeguards that we're asking our licensees to put in place. And, you know, thinking about the consumer's experience walking into a social consumption lounge, social consumption space. First, we start off with providing as much consumer information as we can about the products that are available. THC, some of the testing data, anticipated time of feeling the edible or the pre-roll or the product that you're consuming. So starting That's kind of level one. In terms of ensuring public health and public safety. You take it to the next step, which I consider the RDT training, right? How are we properly training people that work in these establishments to recognize somebody who might have, might be demonstrating signs of impairment. How do we recognize those people? What other procedures might people have as it pertains to, again, dealing with a patron who, again, might be greening out, as they call it. So it's the training piece. That's the next level of public and health and safety guideline. You get to the third level, which I envision is the transportation plan. Somebody is having a bad reaction. Somebody is not feeling well. Somebody is anxious. Somebody is maybe, has stomach problems or nausea, rapid breathing, anxiety, paranoia, any of the potential bad side effects. So there's an effort there to help if we are truly hoping and envisioning our licensees being in the hospitality business when it comes to operating a consumption lounge, they should want to be in a position of trying to take care of their customer. A third level is helping somebody get home safely via their transportation plan. And the fourth level is kind of the last measure of somebody is having that adverse reaction. What can our licensees offer their customer? Again, putting on that hospitality hat. We're here to make sure you have a good experience. We obviously want you to come back. We want you to get home safely. Is offering a cool down space, a place where somebody can go get out of the kind of panic or anxiety or paranoia they might be feeling. Their increased heart rate, a quiet place for them to kind of step out of the hub of the social consumption activity and just allow themselves to kind of just collect themselves, feel better, have water, have food. If there are products that our licensees want to make available, like, the new Undo product or any other products that might come along, and that's where I like the inclusion of this language. It's a voluntary decision by the consumer. So moving past what we heard, public testimony wise of, I'm not dragging a consumer off. You're simply approaching them and saying, I can either get you a ride home, or if you want to stay here, we can offer you a quiet place to go. Just kind of get over this anxious moment you might be having, or this, period of panic or anxiety. We can offer you Undo, we can offer you water, we can offer you food. There's a whole other litany of, proposed remedies that people find interesting or usable. I just think if we're sticking to that hospitality notion, I hope none of our licensees would say, oh, you're throwing up, you're being anxious, paranoid, we're going to help you out the door. I don't think it's necessarily the best step either. I appreciate that we don't want to, impose any undue or unnecessary costs on our licensees. I don't look at this as one of them. I look at this as you're helping your consumer, you're helping your customer. Go ahead.
I do think there's a cost because we're saying shall be a space free of marijuana and marijuana products. So it sounds like it's going to have to be a walled off place if it can't be around products. And this is actually one of the things that I spent probably hours with attorneys Bruno and Baker talking about how we delineate the consumption area.
Mm-hmm.
So we still have not fully agreed on how we delineate a consumption area. So now what it sounds like to me is we're going to have is it going to be, does it have to be opaque? Does it have to be a darkened room? How are we, because there will be cost, because if it has to be away from products where they're walking into a place where products are being sold and consumed, it feels like, and this is where I think that hospitality, we don't do this in bars, right?
Mhm.
You've been a bartender, I've been a bartender, I think. I'm not a very good bartender, but I've been one. And I understand that what my job as a bartender is that you help someone when they're having ill effects of alcohol. How do you safely get them home? Here, it's almost like we're encouraging when they've overconsumed to stay. And I'm not sure if that's something we should be encouraging. We should, if someone is greening out, if someone is overserved, we don't want them getting on the road. But I see this as an added cost. I don't know if you can describe what it looks like. I don't see anything here. So I would second the motion to strike. And so I don't know what your thoughts are, but if everything you said leading up to a segregated, what I think probably has to be opaque space, I don't think makes sense for our licensees. And again, I've heard from people who front of the line trying to get some of these licenses, who already run bars, who have said to me, I just want to get somebody safely home. And that's ultimately, but I don't know why we want to keep people around, especially someone who's already intoxicated, and let them make a decision about walking into a corner. And I don't, how do we define that space away from products? What does that look like? Can you keep me?
Sure. Sure. And I think the language, probably the language here is a lot more flexible. And had this conversation with a SCP licensee who raised the question with me of, well, can I just direct somebody into my office so that they can sit there, be out of the way, be out of the environment? And if in their establishment, they have an office space to allow them to get out of the consumption area by going into somebody's office. Can I make that available? And I think we're leaving the language that flexible to allow somebody to do that.
Flexible, it has to be away from products. So,
Yeah.
So I'm saying, so what if they have secure records? What if they have?
Restricted area.
Yeah.
Away from product.
Area. I thought, isn't that? Well, I would agree with Commissioner Roy that we should have to strike this language. I'm just really.
I would not agree with that. But
Yeah, I mean, I think we heard overwhelmingly, folks said it felt discriminatory in nature, punitive. We had an equity licensee, the same person I believe you're referring to, say that the ABCC instructs us otherwise. If someone is intoxicated at a bar, we don't want to keep them there. We want to help them get safely home. And so, and then putting them in the corner or the whatever room could induce more anxiety in someone. And so you can't put somebody in an office. It's a restricted area. It's like, and if it's away from products, they're going to have that air handling system in that special area. And they're going to pay, if they're in Boston, they're going to have to pay extra square footage for that area. So there is a significant cost, I feel, associated with this.
Do we really, if they're not feeling well and they're overserved, do we want them to stay? Why do you want them to stay?
I think, again, it's a good question. It gets to the level of what do we want our licensees to offer an individual?
Do we really want to encourage someone who is overserved, who is maybe feeling sick? Why do we want to keep them in a confined space?
Again, recently just talking to, I know we all did, we talked to the folks who ran Diaspora, ran this notion and idea by them. They certainly saw a need for that.
Can I say, we actually had a conversation just 2 weeks ago, and what the owner of Diaspora said to us, and I attended with Commissioner Wright and Attorney Baker, was that when they first opened their business, I think that it might have been part of, because it was obviously, it's generous, it was the first time Cambridge had anything. I think that might have been a local agreement that they have nurses, and she had nurses, and she had a sort of storage space, but she is not I mean, if you heard from her, she is not selling product there. She's just facilitating the consumption.
Right.
So that's the difference.
Right.
And I think that you're going to be creating, a nightmare. It's going to add significant cost, but more importantly, the last conversation we had with her, I did not hear her saying that she did not endorse this.
Oh, she conveyed then a different answer to me.
Okay.
If I may, Commissioner Simmons, you mentioned in your opening comments, cool down spaces, and then you mentioned a conversation with Dr. Tischler.
Mhm.
Was it, you joined them together? It was conjunctive. Was it? Did I hear that right? And what did he say about?
I had a call with him yesterday that Kate Fisk and Andrew, who know him through our medical program, he's also a member of our CAB. I walked through kind of what we were proposing a cool down space. His comments were positive about it, just in terms of, again, getting somebody who might be feeling a heightened anxiety, paranoia, any of the other kind of greening out symptoms that people have, and just suggested to me that, a cooling down space or getting somebody into a quieter space away from the consumption area was not necessarily a bad idea.
Mr. Wright?
So does this apply to all three license types?
I believe it does, yes.
Attorney Bruno, this would apply to all, yes?
My understanding of it is that yes, so it's at 12A, social consumption establishment shall offer a designated cooling down area that is clearly marked with signage.
Okay, so how at a music festival do you get them to the quiet space? How do you do that in?
Away from product.
Yeah, away from product. How do you do that in, the tiny one-room yoga shop?
Again, that's kind of a plan for them to give to us. What is going to be that space away from product and away from the consumption area?
Yeah, I'm not hearing that. I don't see that. It's basically saying that they must be away from where product is sold or consumed. So give us your example. We have a big yoga studio right here, right? And this is it. This is it. So what do they do? How do you? They go in a closet, they go, where do they go?
If you'll permit me, let me step back a little bit, because I think at our public hearing, and I tried to make the comments at our public hearing, is that our licensees had a different thought process around this. They're like, I'm seeing somebody impaired, you're telling me I got to drag them into another room. That's not it at all. It is about, hopefully, the hospitality nature of our licensees saying, you're under duress. I can offer you a ride home if you wish to
They
stay,
should do.
which,
Well, why would they stay?
or if you're experiencing something that you think will pass, we can give you some food, we can give you some water, we can allow you to step out of the way. Again, it's, for me, it's a good business practice for somebody to say, how can I help you right now? And if somebody says, I don't want to go, just say, okay, here's another alternative we can give you.
We're saying shall, and we're describing the parameters of it. So it's not just a business decision. We're literally telling them they have to wall off an individual who cannot see other people consume. I mean, we don't do this in bars. We try to get them home safely. And I think it would be counter to public health to say you're already overserved. You're already, and we think it's good for you to stay here. And you get to choose why you're already overserved and compromised. And I just don't think that decision process of someone who is already under the influence, suffering from whatever, that they're necessarily going to be in the right frame of mind. And everything you've said, it's offering water, offering products, helping someone get a ride home. All of that is hospitality, but hospitality is not. I don't know how that person makes that decision. I think that it's almost like tips. Someone at that establishment is going to have to make that decision for a person who is compromised, who is inebriated, who is, again, under the influence. Their judgment may already be compromised. So I don't know how good hospitality in bars
Mhm.
says that we have to walk up to you and say, we see that you're falling down. You gotta go home, and we're gonna help you get home safely. Not, why don't we take you into our office, let you sit down, and then you can come back to the bar. I don't think anybody in the alcohol license system is gonna do that. And I don't see how that's hospitality. So, Commissioner Roy, I think we can move on, because I think.
Yeah, I just, to the additional cost that a marijuana establishment agent shall monitor consumers in a cooling down area for safety. A marijuana establishment agent shall remain present until the consumer chooses to leave the cooling down. So now we need additional staff to monitor the cooling down space the entire time person is subjugated to the cooling down space.
I think we can move on. I mean, this is gonna be, you know, I don't know if this is something to die on the hill for, but I think we're just gonna have to move on, because I don't think we're gonna find any consensus here. So,
Sure.
go ahead.
If I could. Yeah, listen, I appreciate the conversation, appreciate the discussion, appreciate the many folks that we've heard from, and realizing, you know, I still see this as a valuable component, and there may be a way to reword it or address some of the concerns that you have, and might even be a cooling down protocol. I mean, without necessarily definitions of designated space, but I'd be happy to continue to work with our team on it.
I want to strike it. So that's
Okay.
my position, Commissioner Roy.
Yeah, and I concur. I want to strike it too, because respectfully, Commissioner Stephens, you're the only person I've heard full-throated endorsement of this. Like, we've heard from countless stakeholders, heard from so many people, and you're the only, like, I haven't heard from anybody else that it thinks this is like helps or is a great idea. So respectfully, you're the only one that I've heard.
Okay. No, listen, I appreciate that. I think it's just an extra level of, you know, protection for public health and safety. And again, I recognize we don't have consensus to strike it, but what I would suggest is I'm happy to continue to kind of work on this and maybe bring back a solution that you'd be amenable.
Hey, don't waste too much time.
No, I will. I think it's that important,
Right,
but thank you.
Attorney Baker.
Sure. And thank you, Madam Chair. Just to offer a bit of context here. So we've had a number of drafts throughout this process, and one of the drafts had this as a may, and it's an SOP. So just offering that for the board, where right now it's obviously under 141.12 where we're requiring it for all. However, given the divide right now amongst the board, just trying to offer brainstorming here for a solution.
Can I tell you, I think that this is more appropriately put in guidance.
Mhm.
So that's kind of where I rest right now. So we can move on.
Yeah, and if I one last way, I just quickly look at California, and it's not mandated. It's more of, like you said, a guidance, a may, if they want to, optional.
All right, we can move on. Thank you. Thanks for that. It was good debate. Thank you.
Madam Chair, if I may.
Attorney Bruno, yep.
We will be on page 123. I just realized the microphone wasn't on. We will be on page 123 on 500, 150 edibles. And under section 4, dosing limitations. This is a very minor amendment. A marijuana product manufacturer may not prepare, and a marijuana retailer or social consumption establishment may not deliver, sell, serve, or otherwise distribute an edible with potency limit levels exceeding the following limits, which includes the 10% variance allowed by 9 through 5 CMR 500-160, section 12, exceeding the following as tested by an independent marijuana testing facility licensed in accordance with Massachusetts General Laws, Chapter 94G, Section 15. I'm not going to read the remainder of the subsections. The amendment to this section was after the words may not deliver, sell. The addition is to include serve, because we now are including acts of service in the hospitality realm.
So just again, only because I have missed a great deal of the testimony, can you just share with me what the thinking was again about the serving maximums and just walk me through a little bit of that. Don't take too much time, because obviously I'm catching up with everybody.
Sure. So the inclusion of service is kind of a differentiation from necessarily specifically a sale. And so, you know, a lot of public comment included, you know, the visuals of service at a table versus, you know, you're going up to a counter and buying something right at that moment. Also kind of the act of running a tab. And so with that hospitality broad mindset, we have broken out kind of a differentiation between just a straight sale, more, I guess, akin to a retail experience, and also service, which is a big piece of what we heard that potential social consumption licensees kind of envision for their businesses. And so in kind of developing that, in addition to, for example, limitations on sales and at the point of service, how much you can be served. And so that point of service language was included, as well as a definition to kind of define at one time, like what you can be served at one time.
Which we're dealing with in other places.
Yes.
in Here, and we've gone over, but I also am thinking, again, because I wasn't here for all the testimony, the 5.5 milligrams serving, that has been consensus that we have determined that is one serving. I mean, that is one Betty's Eddies. That is, that is sort of a standard serving size, if you will.
Madam Chair, if I may, yes, excuse me. So this subsection specifically is explaining what a serving size is permitted to be for an edible. So, you know, the 1 square of a chocolate bar, that's the easy.
But that's
example
standard again.
yes.
I just, you know what I mean? I not having been here, so, but that is standard. That is basically what we're talking about here.
Yes.
And is that the same thing for infused drinks and things like that? That is the standard serving size. So I don't think we actually talked about that when we were going through some of the stuff. In terms of, I get it now, I get it. So, Commissioner Roy?
Unless it's stated otherwise, and it might be, and if it's, so I'm going to apologize. Should we add delivery operator?
And this is because there are some potential other options that might be, why do you want?
Well, we expressly say, because we're expressly saying retailer or social consumption establishment. And so delivery operator is essentially a retailer on wheels.
Yes.
So should it be inclusive of delivery operator?
Attorney Baker is shaking his head. Yes. Okay. Are you in agreement?
I am. I'm just wondering if we need to capsulize the language a little bit more. Marijuana product manufacturer may not prepare, and do we just want to leave it as a, picking up on Commissioner Roy's comments, we want to talk about everybody who's eligible to serve. So it's beyond a marijuana retailer, it's beyond the social.
Caught up, I mean, social consumption establishment
Yeah.
would cover that.
Fair enough.
You're thinking like micro business, cooperative.
Yeah,
Then you
but
would
if they're all,
Apply for the social consumption establishment license.
Right.
We cover that.
okay.
Attorney Baker, if you want.
Thank you. Yep. 140, sorry, 500, 146 2B covers delivery operators and cross sites to this section, so it would be in compliance. So it is covered with the cross citation later in the regs.
So why did we put retailer in here?
I mean, you're just saying even if it's cross-referenced someplace else,
Yeah,
it just
we-
might make sense.
Put
put it
retailer,
there
not
as well.
retailer.
Yep, I don't.
Yeah, I mean, unless there's some reason
No,
not
it's
to
a
do it.
strike retailer and cross site or add delivery operator.
Does that make sense?
I don't disagree.
Okay,
all right,
thank you.
Thank you.
Thank you. All right, moving on, Attorney Bruno.
Thank you, Madam Chair. The last staff amendment for this list for 500 is on page 116.
Sorry,
This,
Erica, what, sorry, what page?
116.
Go ahead, thank you, sorry.
Sure. Thank you, Madam Chair. This is additional operational requirements for marijuana delivery operators, subsection 2, limitation on sales. And this would be subsection 2D, a new addition.
Yep.
So legal would propose a delivery operator may sell non-infused food, water, and drink items that are prepackaged prior to arrival on the premises and are shelf stable. Such sales of shelf stable products shall be limited to products sold in a manner that does not cause the delivery operator to be considered a food establishment under 105 CMR 590.001. The delivery operator shall obtain all licenses and permits as necessary prior to the sale of shelf stable products. This was from some feedback that we received as far as questioning whether delivery operators would also be able to sell shelf stable products. And for consistency with really all licensees that are permitted to sell, I understand from as business to consumer, they'd be able to sell those shelf stable products. It's I'm sorry, Madam Chair. It's the same language taken, for example, from the marijuana retailer section that allows for the sale of shelf stable products.
Right. I think that we have consensus on this, yes. But Commissioner, you have
Yeah,
questions?
160, what page in the board book, do you know what, I mean, like,
It's not lining up.
I know, and
It's
I'm
not
having,
lining up.
yeah.
yeah,
We don't printing in other.
Oh, I apologize. So this actually won't, because it's a legal amendment, it's on the page guide, so the language isn't actually showing. Yes, absolutely, absolutely.
copy, like,
I know, find it. I'm just looking at this. In the chat now.
Please, Attorney Bruno. So it would be nested under 500, 146, 2D.
Yes.
Thank you.
Any questions, Mr. Stebbins?
I'm good.
Okay, can we move on?
Yep.
Thank you.
Thank you.
Attorney Bruno?
Those are the staff amendments for adult use that we have at this moment. If you would like, we can turn to the medical amendments. Those are very, very minor staff amendments.
Thank you.
For efficiency purposes, just looking at the page guide, under the definitions, these are amendments that the board has come to consensus on for minor grammatical issues for both of those, technical issues for the definition of inversion and registered qualified patient. If the board is comfortable, we can consider those adopted as well for the medical as you adopted them for the adult use.
But we've discussed this.
Yes,
So,
yes.
okay. So are there any questions or comments from my fellow commissioners? Hearing none, we can move on.
For medical, we would turn to page 30. If you bear with me for one moment.
Or page 15.
So
15. Oh, no, we just did registered, or did we already?
No,
Okay,
If I may, Madam Chair.
yes, thank you.
So I'm sorry if I wasn't clear, but for both of those definitions, inversion and registered qualifying patient or patient, those were both very technical amendments that the board came to consensus on at the last meeting. The changes are the same as those in the adult use section. And so as long as the board is comfortable adopting those changes for medical, we can move forward.
Thank you.
So we would be on page 30.
Thank you.
And this is, again, a very technical amendment. I'm just heading there myself. It reads under section 6 of 501029 registration and conduct of independent testing laboratory agents. A registration card may be renewed thereafter on a triennial basis on a determination by the commission that the applicant for renewal continues to be suitable for registration. The change there is to triennial. It was some redlining and spelling errors to ensure that it was a triennial basis instead of an annual basis.
And this was something I think, Commissioner, that you were looking at differently and trying enough. I don't have any questions here. Commissioner Stebbins, are you good?
Thank you, Chair. I'm good. Yeah, this was, I think our intent here was to keep ITL agents on the same renewal opportunity that other ME agents had because they weren't consistent.
Thank you. Okay, moving on.
The next amendment is on page 54. And this is 501-105, notification and approval of changes. This is the same language that was considered, I guess what we'll call the foodborne illness amendment with the proposed language from the Department of Public Health and the reporting requirements for that. We would of course, adopt the same requests to be included for non-infused food or drink, as well as striking agents so that it's the marijuana treatment center that's required to report. But considering that there's already been discussion and consensus for adult use, if you're comfortable moving on, we can go to the next amendment.
Okay, thank you. Any questions? If not, moving on.
On page 70.
Go ahead. Thank you.
And this is 500-110 security requirements for medical marijuana treatment centers. It's 500-110-1L, which reads, ensuring that all marijuana and marijuana products are sold and stored out of plain sight and are not visible from a public place and outside of the marijuana treatment center without the use of binoculars, optical aids, or aircraft. There was just the missing word and so we've included that there.
Thank you. Any questions or comments?
Where's the and go?
Between sold and stored.
And stored.
So currently I don't see,
Sold and stored out of plain sight. Is that what you're saying this is? Instead of kept out of?
so replacing kept in the current regulations with sold and stored.
Madam Chair.
That's what I'm saying.
I'm sorry, Commissioner Ray, could you just?
Sure, absolutely, Attorney Bruno. So currently I'm in the published record 501, and L reads that ensuring that all marijuana products are kept out of plain sight and are not visible from a public place outside of the MTC without the use of binoculars, optical aids, or aircraft. So are you striking kept and replacing it with sold and stored?
Madam Chair.
That's what I see, yes.
Yes. So in the version that was submitted to the secretary and commented on, there was the change to sold and stored, in part for consistency with, for example, although there's no consumption and service for marijuana treatment centers, I think it was more clarification to elaborate that it was sold and stored instead of just kept out of plain sight. And so in part, it was that consistency with the change to the adult use as well.
Are you pleased with the?
Yeah, I think I am, but I wonder if we should keep kept, sold and stored. And the reason I say that is because you could have a Sally port where you're not really storing it and you're not really selling it, but you're temporarily keeping it there. So that's what I'm thinking we should keep: kept, sold, stored and sold.
I certainly, Mr. Stebbins, are you okay with that friendly addition of language?
I am. I guess the other question I might have, not to dive too deep into this, is do we want to use the word or instead of and?
Madam Chair, if I may,
Oh, please, Attorney Brewer.
all very easy, friendly amendments to adopt.
Thank you. Okay, thank you. Moving on.
Thank you.
Attorney Bruno.
And the last staff amendment in medical is on page 120.
Go ahead. Sorry.
And this is under 501-850 waivers. It's subsection 3. And this is waiver of security requirements. Any waiver of security requirements under 935 CMR 500. Oh, sorry, 501-850 shall be requested under 935 CMR 501-110-2B. It was in site correction.
Yeah, 820, it was 820. Okay.
Can I ask it may not be. Do we use artificial intelligence to help us track this stuff at all to keep this consistent?
We need
Is that available?
If I may, Madam Chair.
But again, lawyers don't really like artificial intelligence.
Yeah, but it's gonna be cost. I know it's gonna be a budget question.
If I may, Madam Chair, I did ask our CTIO, Paul, there has been some discussion of when it's appropriate to use AI for various state agencies, and there's no direct guidance that we have right now. I believe he has a meeting actually tomorrow of a number of different organizations under the state, and this is one of the questions that I'm still looking for additional clarity on. Obviously, wonderful tool, and yet we want to make sure that we're working within those guidelines, so more to come.
Thank you. I mean, as I've heard, it's like really good to help you kind of flesh out your broad arguments, but when it comes to, but I'm just,
Yeah.
but it feels like there needs to, it's almost like a spell check, that there must be a higher capability spell check that helps you make that consistent. So anyway, just again, just a quick question. Thank you for that
Yeah,
response.
thank you.
And thanks that Paul's coming running in.
I'm not sure what we're talking about.
But you got it all under control. So I just raised it again, because I am the queen of non sequiturs, just asking because we had a minor, adjustment in terms of referencing the code. I just said, can we use artificial intelligence to, I'm not saying do legal research for us, but just make sure that it helps us, almost like an automatic spell check. And he said, you're actually going to be having this conversation tomorrow at your meeting or thinking about it.
Sure, thank you. So this is certainly a very topical within the state CIO council on uses of this. The general guidance to date from EOTS has been to limit use of artificial intelligence, especially the generative AI like ChatGPT. Copilot, Microsoft Copilot, it's a different.
That's a team space.
That's a Microsoft base. So all the information in that resides in our tenant, just like with our other data. So trying to not get too technical, Copilot is safer than ChatGPT for most things. Clearly, if you're doing like essentially a Google search, it's okay, but anything you put in, so if you take a document and upload it to Gemini or ChatGPT, that document is now forever in that. And it's not even like you can go and say, please remove that from those engines, and they're used to generate additional, the way AI works is it's pulled in as much information as it can, and it just keeps pulling in more information, and it just looks for patterns across hundreds of millions of documents and feeds and all kinds of information. And so any information that's put in just goes into that pool and is used in the future. So the caution that always is anything that's sensitive, anything that's not public, we definitely don't want to be uploading into the public generative AI like ChatGPT, and I don't want to use them just only, but certainly often people refer to it, Gemma.
I'm just thinking like supercharged, spell check, right?
Mhm.
That at some point in time, I'd love to hear more about this, but anyway, I
Glad- glad-
raised it because I think about, this is why I'm a recovering attorney, because I don't like doing this kind of stuff, and it makes my head explode trying to, and I applaud all the work that our legal team, our paralegals have done to do this work, but it feels like there might be a tool that helps them, but that was the only question.
No, sorry. So, well, thank you for the opportunity, and I'm definitely glad to talk more about it. It's a very complex and very topical conversation, so.
Yeah.
All right.
If I may,
Well, thank you,
So
Commissioner.
to that point, that's very helpful, but these are public documents.
Mhm.
So something like this is, regs are public, so something like that, do we really mind if it goes into the, AI sphere, if you will, and
Yeah, I mean, that's I think is a much more complicated conversation on thoughts and impacts of what that may be, especially documents that are being in work product as you're working through them. Certainly documents that are in these meetings are very much open, but work product being done behind the scenes may or may not be. Obviously, anything that has PII or sensitivity with it, that
Yeah,
would
of course.
certainly
Yeah.
be such, because these are public documents, there's lesser concern. But I think there's some stuff that certainly with the GC's office and, we're getting some, guidance again from EOTS and other agencies as to what the best use cases are. I know the comptroller's office largely forbids, the state of EOTS does not allow the transcription services to be used for recording meetings, even public meetings, because once it's recorded, things that you might otherwise redact out are there and can't be redacted out. So,
Well, thank you. It's a subject for later, and but again, then we would need our lawyers as much. So thank you very much. I appreciate the explanation, and thanks for catching that. Appreciate it.
I like the fact that you can just mention Paul's name.
Sprinting, yes. Thank you.
Paul. Thank you very much. All right, Attorney Bruno, moving on.
Yes. Thank you, Madam Chair. And so now we are at Commissioner decisions in adult use. I'm sorry to have you guys be going back and forth, but we're now back to the adult use regs on page 78. And this is 500-110 security requirements for marijuana establishments, specifically.
Can you just hold on just so?
Yes.
Of course. Thank you. Just let catch up. So just state where we are right now.
Yes, Madam Chair. Page 78, 500-110, 1L.
Okay, yep.
And this is specifically in regards to consumption and service in public view. I'll read the regulation. Ensuring that all marijuana and marijuana products are sold, served, stored, and consumed out of plain sight and are not visible from a public place outside of the marijuana establishment without the use of binoculars, optical aids, or aircraft.
Commissioner Run.
So should we harmonize the language and add kept in or to Commissioner Stebbins' point?
Please, Attorney Bruno.
Madam Chair, we can certainly, to your point, Commissioner Roy, we can certainly include kept in there as well for consistency throughout.
So is this also part of, this was the conversation that we were having that I'm trying to wrap my head around in terms of out of plain sight. And we are talking about all products, not just combustibles here, right?
Yep.
We had a very robust conversation about what out of plain sight is, not a public site. And I'm just trying to figure out still, because we know that the statutory language is obviously not discussing consumption. I I understand Commissioner Roy has an issue more with combustibles, but where is this coming? Is this, but you know that what I raised, the outdoors, we're having the outdoor festival, and in terms of what is in plain sight, what is not in plain sight, you know, again, Boston Common, Harvard, whatever. How are we working with that? Now, I understand the part that's in statute, but in terms of, especially when it comes to the, you know, the events, that may be in outdoor locations, how are we doing that? This is again, not a hill I'm gonna die on, but I just want to make sure that what we're doing is enforceable. I still am not quite sure what in plain sight means, because when the original statute and regulations were drafted, at that point in time, we didn't have social consumption. We didn't have that framework yet. We had the law, but we didn't, you know, we hadn't been. So just, can you help me walk through my own mental gymnastics here on Attorney Scheffler, because you were part of the conversation. So sort of help me get my arms wrapped around it. I may have a different perspective than some of my colleagues, but I think you know where I was landing, and trying to just make sure that we have regulations that are enforceable, that are not going to create problems. And again, it might be that a municipality is very clear about what that is. So I'll let Attorney Scheffler first, and then.
So just a little perspective from the working group as we were trying to tackle this particular question mark. So there is generally understood, at least the industry kind of understands what out of plain sight means. We've seen retailers, the frosted glass, and they know what that means. When we originally approached this and we looked over the statute and said, consumption's not required to be in there. That was part of what went into breathing some vitality into outdoor events. So that was a part of the working group's considerations, especially with like the idea of outdoor smoking. You could have a space 30 feet away, but it would necessarily have to be an open space to allow free flow.
But this was because, and this was, again, you guys, I really appreciate your spending so much time with me, but when we talked about, well, a tent, okay, and maybe that keeps things, you know, a tent with opaque, whatever, but then we will be enclosing smoking in an area that I think we assumed it would be open air. So that was where I am sort of mixed in between here, is that how do we have that opacity, but also make sure that we're not doubling down. I'm less worried about the others. It's really the smoking, and how do we facilitate that?
If I may, Madam Chair,
Please,
I may be pulling this from my head, and please check me if
that's
I'm
a
wrong.
better anatomy that I'd like it to come from. So thank you very much.
It can always get worse. But I believe that would actually introduce a conflict, because if we were to say put a tent around the outdoor smoking area, you've now introduced barriers which turn it into an indoor smoking area. I believe the way our regs are written is you can have removable barriers, but as long as those barriers are in place, like tent flaps, for example, it's an indoor enclosed space. When they're raised, you can say it's an outdoor space, because it is, and I believe some of this was largely borrowed from the rules around tobacco smoking, at least as an original source point, around the free flow of air through a space that you are going to permit outdoor smoking. That may introduce a conflict between those two provisions.
Thank you. Commissioner Roy, then Commissioner Stebbins.
So
Commissioner Roy?
I think we might be conflating in plain sight versus plain of sight. Those are two different things. In plain sight, and then your plane of sight.
This is out of plain.
So that's why we maybe need to have flush this out. So is your concern plane of sight? It sounds like.
That plane is spelled P-L-A-N-E. This is P-L-A-I-N.
Plain sight. Right. versus plain of sight. So
What I'm not, this is of plain sight, and I'm saying, I'm not,
easy, meaning
plain sight means you can't see it. You can't see it.
something is easy to see if it's
Yeah.
in your
I
plain.
mean, my plain of sight is here, but in plain sight. Yeah, they're related, but they're not the same.
They're not the
So
same.
what I'm trying to figure out is, it's just like the question, it's the question that I raised.
The frog pond's plain, you keep talking about the frog pond. That's the plane of sight. That's not in plain sight. That's
It depends on where you're standing,
the plane of sight.
but in plain sight, if I'm standing up on a hill and I look down, it is my plain of sight, but it's also, I can see it, it's in plain sight. And I'm saying, how high does the barrier have to be to keep it out of, I just want,
Plane of sight.
what else, it's the point that I'm raising with the lockdown or with the cool down.
Oh my goodness gracious.
The cool down space, it's what I'm raising in terms of, I raised this with the staff, when we have an inside consumption space, I have asked them to come up with language because we have said that consumers basically, I'm thinking of a local retailer, right? And they have room, and we're gonna have allowing on-site consumption inside the footprint of an indoor retailer, not smoking, but I've suggested that we need to have, whether it's signage or whether it's a rope, but because we're requiring that consumers can't be walking around the whole space, what does that look like? So all I want is, I'm not disagreeing with I understand your hesitation about especially kids observing smoking. But I just want to know, what does it look like? Depending on the venue, what does it look like to be out of plain sight? Meaning if I'm up here and I can look down, that's in plain sight. Could be my plane of sight also, but in plain. Attorney Baker, and then, okay.
Thank you, Madam Chair. Just to kind of orient this conversation with the legal parameters around it, I put in the chat, 94G section 12C. I just want to state that for the record so that we can understand what the statute's saying, and then we can amend regulations accordingly if we so choose. So no marijuana establishment shall allow cultivation, processing, manufacture, sale, and display of marijuana and marijuana products to be visible from a public place without the use of binoculars, aircrafts, or other optical aids. So really, in my opinion, it's visible from a public place is the term of art that we need to comply with here. So just pulling that into this conversation without optical aids, right? So in saying that, I mean, we can definitely tweak the language of out of plain sight to be more specifically in line with the statutory language there, which would be, not visible from a public place.
Could you drop that? Yeah.
Yes.
What are we going to require them to do to keep it out of plain sight? When we had the conversation that I think Attorney Scheffler pointed out, that you put it in a tent in an outdoor field. I mean, I could see that, but then we think about the other public health issues on the other side. Attorney Scheffler, and did I not recognize?
No, I want to pick up on some point, but I want to.
Attorney Scheffler, and then.
I also want to just flag that this section is not limited to simply smoking. This is any marijuana or marijuana product. And the reason I feel that that's important is in some of the discussions of the subject in the working group and outside of it, we're dealing with festivals in a urban environment like the Lowell Folk Festival.
Right.
Where you'd have, what was envisioned in the working group was sort of a beer garden kind of thing. You may have a tent where the sales, storage, where it's being kept is out of view.
We can agree on that. That's easy.
Okay,
Yeah.
that we're good there. But then you step outside into the consumption area, which may be just, a simple barriers, place to sit. As written, there would now need to be some sort of privacy fence, some sort of large barrier, even if you're simply having, the marijuana beverages or edibles at an event like that. As written, that would require you to put up some kind of make this space blocked off, which also, given the nature of festivals and that might might make that kind of event no longer palatable or desirable to come to. Often you want to, at a beer garden, you sit down, you have a drink and you look at, you get to people watch as well. So I wanted to flag that. If there is, maybe a compromise might be carving out smoking in public events as something separate, but as written, it would prevent, sort of an open beer garden thing from occurring.
That's a compromise. Commissioner Stebbins.
Sure. Thank you, Chair. And I will tell you the benefit of having Philip in the working group is that we all learned a lot about the Lowell Folk Festival. But thank you. But this conversation in the intricacies of this language, it does bring me back to where I think you were going, where should we have a conversation about dividing, it's okay to be seen in public drinking a cannabis beverage or having a cannabis.
Which looks the same as a beer.
Which looks the same as a beer as opposed to smoking.
Right.
So, I mean, is that the conversation you want to have? I'm interested in having it.
I want to make sure that we preserve, especially the outdoor nature, which I think is very exciting for a lot of potential applicants, and it puts in place regulations for something that's already occurring, not all that, without benefit of sales. I think that Commissioner Roy has a bigger issue with the smoking and whether or not kids are seeing smoking. I just am worried. All I want to know is what's the barrier? And that's why I asked the question about cool down. What does it look like? Because that's all I want to know is, okay, if you want to have a compromise on smoking, if that's something that you feel, I can go along with that. But when I hear Attorney Treffler say that this could limit almost an entire class of, not class, maybe that's not the right word, but type of outdoor activities, I get concerned that we're. Commissioner Roy, I didn't even.
Madam Chair, you're from Western Mass.
Yes,
You ever go to the Big E?
Yes, I have.
Okay.
I've chased cops.
Do kids go to the Big E?
Yes, they do. They got red signs too.
Yes. So to the point, is there smoking at the Big E?
But we're, I don't know if they're smoking. I mean, I assume they have smoking.
Designated
areas.
smoking areas.
It's anti-smoking area. And I think, but see, that's not a good example because this is, the Big E is not age gated. All of these are going to be age gated.
It would be age gated if I may,
Please.
regardless of where they're held. It will be that perimeter will be
But
age
that's
gated.
where the Big E is not a good example because kids are walking all around.
But yes, but the Big E could designate an area for consumption event. There's kids walking around. So my concern is not the seltzer or the gummy because this could be that and nobody would know. You know what I'm saying?
Right.
So the smoking where you have a commingling of ages from very young.
You won't have, as I'm saying, you won't have a commingling of anybody around smoking. That's what I'm.
No, so if there's a designated in the far corner of the Big E, they're gonna designate it as a social consumption event. And kids, you have all age groups walking around. So the site plane, do you want young kids to see them smoking, which is clearly smoking, unlike this, which could be anything.
But what I would say is, I assume that the Big E also has designated smoking areas.
The cigarettes get somebody.
No,
Is there
but-
contact
No,
high
but
for cigarettes?
the distinction is, what does a kid see? They're seeing in a smoking area, they're seeing in a smoking area. So that's what I'm saying. I don't see it.
I don't see bongs in the smoking area.
So all I'm saying, I don't disagree with you, but de facto, all of these are going to be age gated, right? And we're going to have some barriers. And what I'm just saying is, whatever that internal barrier is, because you can't see it legally, you can't, under the statute, see it being sold. But now we're talking about consumption, and I'm just trying to figure out, how do we make sure that we don't eradicate this outdoor possibility? And we'll go first to Attorney Schroeffler, and then we'll ask our executive director, because this is a thorny one, and I respect your.
Thank you.
Thank you.
Likewise.
Thank you, Madam Chair. I just wanted to, I mean, playing devil's advocate here.
Me or her? I know, that was rhetorical. I knew it would be me.
The devil's advocate, devil's lettuce, I suppose. I would like to flag that the core concern from a public health and safety aspect that you see kind of rifled through our regulations is avoiding consumption by underage individuals. Not necessarily I saw it and I saw it occur. If we're going to follow that argument, you could say that the consumption of edibles like a candy bar or a drink is more probable to be consumed by a child than like a blunt that you would smoke. That is very obvious smell. The edibles can look like a chocolate bar. They can look like an energy drink. They look like many things. They're far more easily to disguise. So, I mean, if the concern is, if the core concern here, is it the observation of consumption through inhalation, or is it the actual consumption by a child themselves? I suppose is what I'm curious to scope out on this.
Yeah, the thoughts are, Director Ahern.
I think I'm just gonna go back to the things I think I've stated over a few different meetings. So first, just want to kind of put in here an example from my folksy municipal experience here, where, you know, the majority of businesses were in industrial parks. One industrial park example, this was not a CCC regulation. This was a select board decision, which was there's a pediatrician's office with this industrial park. We don't want any line of sight to exist. And that was stated within what the company agreed to do, which is we don't want the loading zone when anything is being unloaded to be seen from the pediatrician's office. That was a municipal decision that was made to say, you know, this location is fine with us. We want to make sure that, you know, and everything was handled with screening, et cetera. In the Detroit example, I think I mentioned last meeting, which is, I think goes to the chair's point of you're in a space, you're in a parking lot in downtown Detroit, you're surrounded by buildings. The state of Michigan's basic point was those are all private property. If they're looking down through the fence, there's nothing that we can do about that. And it's not necessarily our business. It's if you're walking up to it on the street level, that fence, if they had allowed such consumption, would have been opaque and you wouldn't have seen into the seating area. And even if you were in one of those buildings, the tent where the point of sale is fully opaque. You cannot see the actual transactions going on. And then another example, and this was with a different group of commissioners, and I believe Commissioner Roy and I have had the discussions of kind of Tanglewood as an example of outdoor, and it's topically, you know, I think goes more to the chair's point today, which is you have a fenced off area, people are consuming, but I'm at a different location. I'm going to see in over that fence, right? And so I think for that latter issue, I'm not sure, quite honestly, that we can come up with you know, necessarily a solution for that. But if there is a desire for that, I think probably what Attorney Scheffler has provided in terms of smoking would be, you know, certainly with the fencing and those types of things, all of which goes to cost, which I know is one component we've discussed, but also there are solutions. The fencing, you can get different grades of fencing that allow for different ability to see through at different cost ranges. I don't know that there's one that would really answer the question of top-down sight. And from a smoking perspective, again, to actually address that, you've now gone most likely to Attorney Scheffler's point from outdoor to indoor in any way to actually address that.
Thank you, Commissioner Roy.
Yes, I have a question to Attorney Scheffler. You asked me my intent previously, so I'm going to ask you what you feel was the intent of the legislature when they codified 94G, Section 12C. No marijuana establishment shall allow cultivation, processing, manufacture, sale, or display of marijuana or marijuana products to be visible from a public place without the use of binoculars, aircraft, or other optical aids. Do you think the legislature was to prevent them from consuming or seeing? What do you think their intent was with that?
Well, if I may speak only for myself,
Mhm.
I'll adopt a very originalist point of view here, which is the legislature wrote what they wrote with intention and the words mean what they mean. They did not include consumption in that restriction. So consumption, you can see, but they intended to make sure that the sale or storage of marijuana or marijuana products was out of public view. That's how I would interpret their intention on this particular point.
And I think we can all agree, and this is also why we're putting together the red tape reduction committee, because we overregulated in the beginning. And so I just come back to the point where maybe smokers are used to being corralled, and segregated. So, it's not as big an issue because they're kind of used to it now. All I want to make sure is that we don't create something that we can't properly regulate. B, if you tell me how high you think the barriers need to be, okay, fine. But I just want to make sure that the outdoor nature of this, because it can be potentially less expensive. You don't need a HVAC. You know what I mean? That to me, and also thinking again, and we had this conversation last week, there's kind of two sides to social equity, right? There's social equity, which is who gets to be a licensee, who gets to the front of the line, who gets the extra benefits. But the whole reason that we're doing this, I mean, I'm not a huge fan of social consumption itself. I think this is a really, really thorny area for us to get involved in, especially because we don't have standards for intoxication and we're kind of flying blind on this. But since both the voters of Massachusetts and the legislature told us, make this a thing, what I have been told is because not everybody has the option to ingest at their home, or if they're living in public housing or something like that. So that's the other side of social equity, or equity, that I want to make sure that we're protecting, is that if this is one of those lower barrier to entry opportunities that is outdoors, I just want to make sure that we don't put something in place that either we can't enforce or defeats the whole purpose of us being outdoors. Otherwise, I don't know how we can get to the point where you're comfortable, and I know what your issue is, but I'm just trying to think how we do it and then keep this license viable. And if you want to take some more time, this is, I mean, I don't know if Commissioner Stebbins, you have any thoughts on this? I'd love to hear your perspective on this.
Thank you, Chair. First of all, this is a good conversation. As we've been going along, I think there is an ability for us to separate out, and again, I'm kind of picking up off your remarks, separating out outdoor consumption that isn't smoking. So edibles, beverages, I think there's a way for us to specifically kind of carve that out, while at the same time considering how we would deal with outside smoking. So almost separating the two and working the two of those out.
Thank you. Attorney Baker?
Thank you. Obviously, I understand the considerations at play here, just trying to get to a resolution.
Thank you.
We could potentially kind of revert back to what the language was before, which it was kept. So obviously, we're going to amend that to be more specific with now defined terms. So sold or served, we can strike consumed from this section, and we can deal with that under 141, 10, and 11. So that would be in our social consumption sections for indoor and outdoor smoking. So I guess that would be my recommendation, would be, okay, let's leave this kind of how it was, which is, again, stored and sold here, and then deal with the other issues of consumption and service under 141.
Commissioner Roy?
I just think it's ironic that our advertising requirements are more strict than what is being proposed here today.
But we're going to be dealing with advertising. You know, and this is actually one of those things that, you know, I had the conversation with staff about advertising. And when we're thinking about events, we would almost de facto make it next to impossible to have events because we can't advertise. So I know I had suggested we deal with advertising in this round, but I have been counseled by our council that taking the broader issue of advertising up so that we look at it holistically actually makes sense. So with that, so that's also another issue that if we don't allow people to advertise, how are we going to get them to come legally? And we have limited advertising in our brick and mortar, and obviously it's easier for people to find, but when it's these standalone events in a public place or a semi-public place, if we don't fix that advertising, and I'm hoping that that will be one of the first things that we do in the beginning of 2026 is addressing the whole issue, because I think that once again, there are a couple of these kind of almost like suicide pills, if you will. We want to make this available. We want to have these outdoor events. I think people are very excited about it, but I just want to make sure that we don't overly burden that process. So then I don't want to turn this into craft cooperative.
Mhm.
And in theory, the legislature thought that we were like cranberries and we're not. And that's why I don't think we have any commence operation craft cooperative. And that was, and I don't even want, you know, and I'm confident where the legislature went with that was, I think that that's a statute, that it was like cranberries and they're all going to get together and they're going to share. They just don't, it was drafted by people not from Westfield, Massachusetts, who didn't chase cows as a child. So it's sort of understanding how an actual farmer works and putting that in place that sounds idealistic, but in reality, we don't have one craft cooperative license. So I just don't want this to become another craft cooperative license. So I really respect your thinking and I know where you're coming from, but how do we, you know,
Right.
whatever language we can get to make sure that it doesn't become craft cooperative, that's what I want.
Right, and if I may cite the language, prohibited practices, advertising by means of television, radio, internet, mobile applications, social media, or other electronic communication, billboard, or other outdoor advertising or print publication unless at least 85% of the audience is reasonably expected to be 21 years age or older as determined by reliable and current audience composition data. So our advertising is much more strict than what's being proposed here.
And I think that our advertising is prohibitive. So Attorney Baker, and this is very robust.
No, just to clarify, the draft currently restricts it. So what is being offered here is a restriction.
Correct.
So just clarify.
Yes.
But are you stating that you do, how do you feel about the advertising?
Oh, well, I think that's a discussion for another day. Yeah, I don't want to send us far afield. But, and I know that, you know, there was out of the Senate, right? It just, a bill got reported favorably that would allow for loyalty points, programs, discounts, you know, opt-in marketing type of thing.
We should leave this to the legislature.
The advertising?
No, the keeping things behind opaque walls.
I think we have the authority to opine on it.
We do, but here's where my point is, this is where the legislature did not speak. This is where we have to step in. And my only point is, I want to respect your thinking on this, but I want something that doesn't ultimately create the craft cooperative issue. So I just want to understand, what are we segregating? How are we segregating it? And how do we make it so it functions that we want outdoor rather than indoor smoking? It's probably, you know, all smoking is probably not good for you, any kind. So how do we minimize the site and Attorney Baker, sorry.
Thank you. Always trying to expedite conversations
You are.
and get to
I
a
know.
solution. So in saying that, Commissioner Roy, would you feel comfortable working with legal on trying to address this issue offline and then?
Yeah,
coming
sure.
back with
And
with-
I definitely, I'd love to, but my question with Commissioner Stebbins, can you repeat through the chair what you were saying about, were you kind of agreeing with the compromise scenario of just the smoking?
No, what I was picking up was you know, is there a possibility to divide the two, right? Have smoking outside of anybody's plane of view, plain sight, whatever we want to call it, versus we have, I think, the authority to say non-smoking could be visible.
Yeah, I'm okay with that.
Okay.
I think we're actually in agreement
We are.
that, I think we're just talking about smoking.
I agree with that.
Okay. See, there's a compromise. So we just need to figure out, and if you could kindly, you know, work with staff, if you can just understand, because when I heard Attorney Schreffler say that we could potentially be in jeopardy of making these outdoor temporary licenses less feasible. So I just want to make sure that we don't throw the baby out with the bathwater. And we're worried about babies, so we don't want to do.
We are worried, yeah. If I may, so I heard what Executive Director said. So if there was consumption, there would have been did I hear that correctly? An opaque barrier.
Correct. So obviously, again, anybody in those buildings would have seen directly down. But the only fully opaque barrier that existed on that site in downtown Detroit was the point of sale tent. The other fencing around the entirety of what was allowed by the city of Detroit was a fence that had some sheathing, but you could see through if you tried very hard. And their point was, had Detroit allowed them to do social consumption in that area outside of the point of sale tent, but within the licensed area, that they would have chosen a different fencing with a different sheet that would have been fully opaque.
And this was one of the points that I was raising, is I'm almost more worried about the entire perimeter of an outdoor event to keep kids out than I am the subdivision of line of in plain sight. So I'm almost more worried about that open area, and can kids under 21 wander in terms of how we fence that up. So anyway, I'll ask you if you could, go ahead.
Just last before, so we can move on.
Thank you.
I think your concern is, what does it look like? And how do we do it? How do we enforce it?
How do
So,
we enforce it?
right, so if it was in level site, we all know that can easily be done, right? Shrubs or whatever they brought in temporary, that's not that. So now if you're in a high rise and you're looking down, I mean, I don't know how, without a binocular or an optical aid, I don't know how clearly you're going to see that. So my concern is the level. I'm less concerned with the folks on the 15th floor looking down, because without an optical aid, I don't know how clearly they're going to see. I'm more concerned about the level plain sight in the public space or in the space. So that could be a compromise where it's just like level plain sight, not above.
If you can define that, because again, I don't personally have an issue, because I think we have kids seeing people smoke, and I understand that this may be more of a reaction that you have than I do, and I'm a victim of secondhand smoke, probably smoked half a pack a day just by, absorption in my family growing up, so I totally hear you. But if you can work with the team, I think that we can come to a compromise here. I just want to make sure that it's forcible and it doesn't,
So
it's not a reality. I think that we've already agreed. I think that we've come to consensus that the issue that you have is with combustible.
Yeah, and Commissioner Stebbins, are you comfortable with them
That's what he.
smoking it? I just want to get like the smoking aspect. What are your thoughts on that?
Yeah, I mean, I'm interested in seeing language again, kind of speaks to what Detroit would have done, but a level plane of sight versus
Right,
anybody could climb anything.
exactly. A tree, a
Right.
telephone pole.
Okay, all right. I think that we're almost.
We're getting there. We're getting there.
All right, thank you. Thank you very much, and thank you for.
Thank you.
Appreciate it. All right, moving on.
Madam Chair, if I may.
Please, thank you.
The next section is 500-0506 F3 marijuana event organizer, and this is page 32.
You just hold on till we jump on the screen. Thank you. Oh, not good.
Sure, and specifically, we are at 500,506F3E. And this is in regards to the 24 days of temporary consumption events, 5 consecutive days, and a single or multiple submission of the event plan. And so I will just read that language for you. A marijuana event organizer shall conduct no more than 24 single days of permitted sales and consumption activity during a calendar year and shall not host more than 5 consecutive days of sales and consumption activity at temporary consumption events.
Commissioner Roy?
To your point of the craft cooperative, I think this portends itself more to that. Self-limiting. Okay, thank you.
So would you? What do you
Propose?
propose?
Yes,
Do you have any questions, concerns about this language? I'll let Commissioner Wright opine, but if you have any thoughts.
Yeah.
I'm
So
comfortable.
I had asked a couple of times, DGC Baker and what the ABCC does, and I believe it's 30, but maybe you could share that with us, the 30 days.
Sure. Thank you, Madam Chair.
Please, thank you, sir.
Thank you. Thanks for the question, Commissioner Roy. So we had spoken with the ABCC quite a bit over this process. And we also spoke with our counterparts in Michigan to understand their event organizer license. So our draft proposed license type here reflects kind of the combination of both of those. And so going back to your question, the ABCC for their single day liquor licenses, it's no more than 30 days in one location, so that if it was 31 days, they wouldn't approve that. And that's how the ABCC has constructed their single day licenses. And, you know, an important point here was going past that 30-day mark, they had indicated through their experience that then they are starting to, these temporary licensees are really competing with the brick and mortars, and the brick and mortar who is adjacent to them, it's slightly unfair for them because they're paying all that overhead costs to be situated there. So that's where the ABCC landed.
Commissioner Roy?
So reverse, so we have 5 consecutive days and they have, ABCC has 30 consecutive days. That,
Yeah.
Yep, no more than 30.
okay. And then I guess we'll take the 24 single days separate. Do you want to talk about just the consecutive days before we?
I'm happy. Why don't you address your thoughts about the consecutive days?
Well,
I mean, again, because I was not part of the hearing process here, I'm
so the
trying to make sure.
ABCC is not, they don't say single days, they say consecutive days.
The single day is actually in their permitting. It's a single day permit.
Which can also be consecutive.
Yes,
So both can be true at the same time.
yes.
Okay, but, and I've done this, but I can't remember. When you have, basically it's a 1-day liquor license, right? And I used to run my happy hour at law school, so I used to have to go every week, get a 1-day liquor license. But I can't remember, and I don't know if the rules changed. Are these then 30 separate 1-day liquor licenses? Or, and we're still entertaining that. It's just how many we're going to be allowing to be applied for at once. Yes, can you walk me through that?
Thank you, Madam Chair. And yes, you're correct. And that's why ultimately, as a, if you look on our guide doc, we have single submission of an event plan. That's also kind of in consideration here.
Can we just address that right now to see if there's consensus? Commissioners, can you just restate that? Because I'd love to just get consensus on one thing and then let us continue to.
Absolutely. Thank you, Madam Chair. So ultimately, I think for expediency for licensees, for municipal officials and for staff here, we would all like to see one submission for consecutive events, and that would expedite review and approval. So if there's consensus from the board, we can quickly dispense of that.
Commissioner Roy, do you have thoughts on that? Are you?
I agree. I think I raised it actually.
Okay, fine.
Yeah.
Okay, and then Commissioner Stebbins, are you okay with that? Okay, so we have consensus on that. Okay.
Feels like, yeah.
We can have like a cheer break. All right, so what is next, Commissioner Roy or Attorney Baker, what is?
I'm just reading, if I may, Madam
Please,
Chair,
thank you.
I'm reading about the ABCC, Massachusetts. And the per applicant, the 30-day rule applies to, quote, any person or entity. This prevents an organization from using different individuals to apply for one-day licenses to get around the limit. Per calendar year, the count of 30 resets annually. Let's say, while governed by state law, the licenses are usually issued by the local licensing authority in the city or town. It's okay. So yeah, it's 30 days. It resets annually. And it applies to any person or entity to prevent a loophole around the limit.
And the 30 days, and you'd also assume, like, again, we're thinking the city of Boston, right? And that was the, whatever, down in the Seaport area, and there were some temporary beer gardens and things like that. And obviously the businesses down there are competing. You'd assume also that the cities would also be concerned about their brick and mortar neighbors as well, so that they would want to opine on this. So, you know, I think that municipalities would have good common sense, you know, locally. So is your thought that we mirror?
Yeah, I think so.
Yeah, I mean, I can give you a little background on why we landed on 24 single days and 5 consecutive days. I think we drew it out of our experience of, I'm an event organizer. Am I likely doing more than 2 quote unquote festivals or events every month? So we're like, okay, 2 per 12 months, that seems like a lot. And then I think we based the 5 off of, at least, you know, we know the Freedom Rally is over, like, I think Friday to Sunday. Boston Cannabis Week is 5 days. So I think we were trying to allow for some flexibility for existing events to be able to come in under this license type.
Do you have any concern about slightly shifting that to follow what the ABCC does?
So bumping up the 24 to 30?
Yeah. Attorney Baker?
Just for the board's clarity, it's 30 days in one location. That is a lot less restrictive than the current restriction now, which is 24 days across the year. So that would be 30 days in one location, but not to say that it's not 30 days in another location, 30 days in another location. So it could be.
So paint me a picture about why that might not be a good thing. Oh,
I believe the concern is it would be a way to sort of circumvent. You are basically becoming a retailer without going through the same process of becoming a retailer and the same level of scrutiny. Because it's, oh, I'm going to hold 30 days of events in one location. Oh, well, you know, I went down the street. Now I've got 30 days in that location. I keep just juggling between these things, and the same kind of scrutiny that we would give to like brick and mortar is being circumvented in this instance.
Commissioner Stebbins?
Thank you, Chair. And I think trying to solve this clarity around events and how many can be held, I think that's why we have tried to stress to a hospitality license that you could open a brick and mortar facility and essentially have unlimited, whatever you want to characterize as events throughout the year, because you're in that brick and mortar.
We use diaspora a lot,
Mhm.
you know, and our neighbors around the corner, and it's probably pretty clear that what we are doing, I won't say forcing them, but pushing them into a different model that makes sense, that they can do things maybe every weekend.
Right.
And this would not accommodate, would that accommodate this? Or it would-
They
no,
could
then
do
they
that
would
if
be-
they went into the
Then
hospitality
they would
model.
be, yeah.
And we made the licensing, the registration fees all the same, so that hopefully they see the value.
Yeah.
Because they wouldn't have to keep running out for these 1-day permits. It's like, I'm gonna have an event, it's inside my lounge, which I have all of the, I'm complying with everything else that's kind of required of a brick and mortar, but I don't face some of these limitations.
Attorney Schroepfer?
It's also one of the things that perhaps kind of gets lost in translation here is with the event plan, it's contemplated that we have an idea of what kind of consumption you're doing here, or like, what are you actually doing in this space because it's temporary? And because naturally being temporary or a pop-up location, we have to make certain compromises. With the brick and mortar though, it's, you are in a regulated space, and to, barring some, extreme examples, we don't really care what you do in that space. Like one day you could have an event, lowercase e, every day of the year. We don't really care. It's, you are in a regulated space that's cleared for that activity. It's that the event organizer is more asking the question, you are entering a space where this would normally not occur, but we're making room for you to do that. What are you doing? When are you doing it? How are you doing it? And are you cleaning up after yourself when you're done doing it? So that's one of the considerations that seems to get lost. It feels like it's been lost in translation, at least as this has been discussed.
It's ironic. Some of the things I'm arguing to loosen, you're arguing, some people are to tighten, some things it's like vice versa. It's like, exactly. So that's the irony is not lost on me. So anyway, a food truck festival that moves around the state.
Yes.
So with this current structure, I wouldn't, if I have a food truck that has, cannabis gummies and, and so I'm limited. I can't do it all over the state because I'm stuck in this box of 24 days, no more than 5 consecutive days. So I can't do that.
So Attorney Schroepfer, can you respond to what she just said and why that's a good thing and why? So just state it again. You're talking about.
As opposed to the ABCC, which is 30 days. And you can do it in different right? You can. I just want to make sure I'm on sound footing here. Yes.
Thank you. So yes, there are 30 days in one location max. It's almost like
one location, right? And but the how this is prescribed, you cannot, it's in one location, but ours is for the entire state.
Right, exactly, Madam Chair. If I may. So,
right?
yeah,
That's a big difference.
For the entire year, it doesn't matter your location.
Right, that's it. So you can't, so I'm just using a festival that moves around through the summer. And the summer's more than 30 days, summer's more than 24 days.
Right.
So that's my bridge to nowhere craft cooperative, because now this is so prescriptive.
I'm not disagreeing with you again, only because I haven't had the time to sit and listen and ask the people who are testifying. I'm trying to sort of get to a place that is, I want the least restrictive. I always favor the least restrictive. I just want to make sure we're clear.
Right.
And we're not harming brick and mortar, and creating an unfair advantage, but we are creating
or a challenging environment,
an unfair advantage for social equity applicants.
A challenging,
so we're purposely creating advantage.
Well, and I'm arguing to have it more like the ABCC, where it's the 30 days, but not one geographic area. So I'm trying to help make it less restrictive, modeling it after the ABCC.
I don't disagree. Just so.
Yeah, no. This is, again, I gave you the math as to kind of why we came up with 24 days. I'm happy to think about bumping that number up if we want to align it in 30 days. I think speaking to.
Comfortable with that, because I won't say agnostic, but I will pretty much always favor the least restrictive path to getting this done. But all I want is the most prescriptive description so people know how to follow the law.
Mm-hmm.
That's kind of my basic
So for clarity, are we just talking about the 24 single days? Do you want us to make it more clear that somebody can move their 24 days around?
I think they already can move their 24 days around. There's no
Right.
restriction on that. I think
Okay.
it's really, are there potential business models that we are cutting off by limiting it here? And again, we do want those kind of brick and mortar-ish, the diaspora. We do want to gently prod them into that more standard model. But how do we create this opportunity that may be more of a movable feature? That's what I'm trying to get my arms wrapped around. And if you are comfortable with following the ABCC model, which is not all that different than what your group landed on.
Yeah.
I am comfortable with that.
Yeah, I'm.
If you're comfortable, again, I'm not trying.
Yeah, no. I'm amenable to, we want to bump 24 up to 30. Is that what we're?
Yeah, I think that
That's the change
it's
we're talking.
however we can more closely mirror the ABCC language. And if there are any issues that you raise before our next meeting, I would appreciate it. But I feel that this less prescriptive and restrictive language comports with what the working group put in place, but I also think that it addresses some potential restrictions. Commissioner Roy?
I think we're saying different things though.
Oh, okay.
So just by going from 24 to 30 still locks you in at 30. And what the ABCC is saying, 30 in one place. So 30 days in Worcester, but you can, the next month, you can do another 30 in Ludlow or Springfield. But what this says is 30 for the year, full stop. And ABC says 30 days in Worcester. You can do 30 days in Springfield. You can do 30 days in Pittsfield.
And this was the conversation that we kept saying, right? This is going to take a while for us to get this up and moving. And so I think that if we can be less restrictive, mirroring what the ABCC does, that as we are working on guidance, as we are working with municipalities to create this legal infrastructure, I think that we have an opportunity, if we need to fix it, because this is the last license type that's going to be available. Commissioner Roy?
And I just think of our state, and it's like, maybe they want to be in Provincetown in 30 days in the summer, but maybe they want to be leaf peeping in the Berkshires for 30 days during the fall. And so now under this schema, they can only pick, they either have to pick, I want to be in P-Town in the summer or the Berkshires in the fall. So it doesn't allow them to prosper off the beauty and the seasons and the tourism of our state because they're locked into 30 days for the
And we have to keep remembering that not a lot of municipalities even want to do this right now.
But there's some in Western Mass that do,
There are.
and some in the.
No, but this is my point, is that it's almost self-regulating, if you will, that we're going to be working with municipalities to figure out how this functions, and we can get their feedback. So I think this is the least restrictive we can be, if you're comfortable with this, Commissioner Stebbins. And then as we are working with municipalities to implement this, we can hear their concerns. And this is going to take a while for us to ramp up and make real. So I am not uncomfortable with going with the less restrictive. Commissioner Roy?
So then I would make a recommendation, no more than 30 days permitted sales and consumption activity in one location during one municipality or one during a, that would allow them the
Maybe you say in one municipality.
per calendar year. So I think we need to add that would allow them the food truck to go from P-Town in the summer to the,
municipality.
yeah, that's, yes.
Does that function? Because then they can't just move down the street.
Yeah, we were thinking of being a little more specific than municipality. It would be like location or address.
But what I'm saying is, if you do it by municipality, then they can't just walk down the street.
Right.
And so we're still expanding the opportunity, but we're saying you can't go.
From,
And
from
30 days
commercial
is still
street to another street in
Right.
P-Town,
Exactly.
right? And so by you just saying location and address, they could go from commercial street to pick another street in P-Town where they could move to. Where she's saying, so you don't impact brick and mortar because there are some on commercial street. So then the municipality, what you're saying.
I just feel like it's giving broader, we're giving more time per municipality. So we're going from 24 to
30 and the ability to move it
and the
around.
ability to move it, but it also de facto doesn't allow them to do the little.
To encroach on our brick and mortar licensees. That's what we're trying to avoid, right?
Yes, Attorney Baker.
Thank you. That makes sense, but also just another consideration here would be like, if they wanted to do it across town in the same municipality, you're essentially saying they could do it across the state, but not across the town.
They could do it across town. It's just they have a maximum of 30 days.
Right, that's why I'm saying that you would have to tie it to the address. If you're tying it to the municipality, then they couldn't do that cross town 30 days later.
Why couldn't they? If they're having discrete daily licenses that we're going to allow them to apply for, why couldn't they do it for 2 weeks in the Seaport and 2 weeks at Fenway? And again, I'm just throwing that out there. Why?
They could, that's not that's not what my comment meant to
Okay.
address. What I'm saying is that under Commissioner Roy's example, again, going to from the Cape to the Berkshires 1 month after the other. So you're allowing for that cross-state temporary consumption event to occur, but if they wanted to be in one municipality for 2 months, you're not allowing that, but you are allowing.
We're not allowing
one
it.
town.
Right now, we're not allowing it. It's only up to 24.
I'm just asking for clarity because it seems like you're allowing for, 60 consecutive days in 2 different municipalities, but 60 consecutive days wouldn't be allowed within the same municipality.
That's right.
Oh,
And the reason why I say that is because the ABCC is narrow in that they restricted at one address. So
okay.
that's what I'm saying.
Okay.
We could restrict it to one address, then they could go both across the one community they're in, but also across the state and not have it negatively impact them.
Right. Attorney Schroeffler?
I'd also just wanted to flag that, being that we don't license people, we license things. So as an entity, you can also have not just 30 days in the Berkshires, 30 days on the Cape. You can be in both places simultaneously.
Right.
So just that there may also be a simultaneous clock running in multiple locations at once, which in turn does add an administrative problem in tracking everything.
Okay. So, I would like to get a little more clarity, but I think this was a very healthy conversation. I think we're a little closer to being there, but I'd like to get, because we're raising some different options that we haven't put on the table before. So I would love to come back to this, but we do have clarity on how we can apply for multiple licenses. We're not going to make it uniform. We can, Commissioner Wright, are you raising your hand here?
Yeah, just to Attorney Schroeffler's point, it's so that clock's running at the same time. So that gives me 15 days in P-Town and 15 days in the Berkshires. But what if July, I want to be all July and
Well, that's what I'm saying. I think.
I want to be there for the entire month of July. And I want to be in the entire month of October in the Berkshires. How do I do that?
I think that I'm picking up on the point. I think that's what we're trying to get at is expanding the marketplace, expanding the capacity again without competing with our brick and mortar. Because some of this language, the 5 days stuff doesn't even align if we go with
Right.
with aligning with the ABCC. So
We're still keeping it to 5 or not.
not as you call it the ABCC model.
That's out. If you follow ABCC.
The 5 days of the licenses.
Mhm.
Oh, all right. I need.
I'm happy to work with Commissioner Royer. with
Yeah,
a combination of this.
Future.
Of course,
Come up
yeah.
with some language with, because he has,
Sure.
my only thing is, least restrictive, not competing as much with brick and mortar and. Okay. Attorney Bruno? Thank you.
Thank you, Madam Chair. We will stay on the same page at 500-0506F3F, which reads, a marijuana event organizer shall submit an event plan no later than 90 days in advance of the planned date of the temporary consumption event. No temporary consumption event may be held without an event plan approved by the commission. The event plan shall include at a minimum the following. I won't read the subsections. The main aspect for consideration here is the 90 days in advance of the event.
I think that, are we all in agreement that that language is fine on the
Yeah.
90 days in advance, Commissioner Stebbins? Yes. And this was my sales and service, so this is also sales and service.
Where are you, Madam Chair?
I'm looking at going a little bit under, go ahead, Attorney Byrne, are we gonna continue on there? Are we discussing that, or is this already?
If I may, Madam Chair,
Please.
Legal's understanding was that we were looking for, because of public comment as to the 90 days and a request really for a shortening of that period, we put the 90-day period as an area of commissioner consideration based upon that public comment. It's certainly a policy choice as to the length of time that the commission would require this event plan submission in advance of the event.
So the two sides of the coin here, if I can restate just to make, so 90 days, that's what our INE team would like. That's probably what the police chiefs would like. The folks who are running these things are saying, that's kind of a long lead time. But that being said, I don't know if anybody has any concerns about the length of time. Obviously these are competing dynamics, and I don't know whether a shorter time frame is warranted or not, Commissioner Roy.
I just think 90 days is consistent with every other requirement in the regulation, and it does give ample time for INE.
Persuasive, thank you.
Okay.
Commissioner Stebbins, do you?
I've been comfortable with 90 days for
Okay.
a lot of the reasons stated.
I will climb on board. We're good.
All right, wow. I love consensus. So the next subsection is on the very next page at 33. This is 500-0506F3F5 in regards to pre-event public safety briefings. A summary of a pre-event public safety briefing conducted by the marijuana event organizer with local law enforcement, fire, and emergency medical services, which shall address at a minimum traffic control, crowd management, emergency egress, responder access, excuse me, communication protocols and procedures for managing public safety and consumer intoxication. The marijuana event organizer shall document the date of the briefing, names and titles of participating officials, and any recommendations or conditions provided by local authorities.
So this was the issue that I had raised, was a briefing, and has this, so just basically walk through what we had discussed, and I think you went in, you got further background from the Police Chiefs Association.
Yes, Madam Chair. This was a comment from the Massachusetts Chiefs of Police Association. They had submitted a comment to include this pre-event public safety briefing, specifically to address all of the named, I guess I'll call issues with the marijuana event organizer. We did have further conversation with Executive Director Chief Bradley and their general counsel. What they are really looking for is I think they've indicated that this would probably naturally fall during the municipal permitting process, is to have essentially meetings with these respective representatives from law enforcement, fire, potentially EMS services, whether that's individually or collectively. They took no particular position on that. We're thinking of whether it's very large towns like Boston, and it's very hard to get everybody in a room at one time, or smaller municipalities that may not have all of these positions filled or on a volunteer basis at all times. They are hoping to have kind of these, they've indicated that they would work through kind of a template checklist as to what would be important to address public safety wise. They're very willing to work with the commission as well, as far as developing that list and possibly creating a template form kind of checklist to go through. And they, in talking that through with them, this is something that could be, excuse me, submitted along with the event plan itself, or as part of the event plan. The last request that they had outside of that particular comment was what they kind of call a final check-in 1 week before the event, to make sure that there aren't any material changes to the event, whether that's security plans or staffing or ingress or egress for emergency services or traffic plans. Of course, they made the request that there's encouragement that if there is any material change after that date, to please inform law enforcement and emergency services and whatnot, so they can continue to update their plans. But that was the gist of their request.
So one of the other issues that I pointed out in our checklist, making sure that we pay attention to ADA accessibility, because that was, I was speaking to the folks from the Disability Law Foundation. Frankly, that's one of the interest groups that we are supposed to be promoting in cannabis, and I don't think enough for.
Yeah,
for
you're right,
right. But anyway, so my only concern here is that I want to make sure that whatever this briefing process is, that we do create a checklist. So it is, we can't have one department not, and again, having been on the other side of this, trying to get the fire department to come on site, get, you know what I mean, because we do require those, checkoffs on the local level for other kinds of licenses. Just making sure that there cannot be friction at the local level that makes this a non-reality. And first Commissioner Stebbins and then the Executive Director.
Sure. I'm happy, I guess, with what Mass Chiefs is recommending, because the only tweak or consideration we might give, and I think you touched upon it, which is if a municipality already requires that, I don't want them to think they have to do this twice. Do we let that municipal meeting count for our pre-event public safety briefing? So they're killing the local requirement as well as meeting our requirement at the same time. But if that doesn't exist, then this is kind of standalone and needs to be abided by.
That's a good idea.
Madam Chair, if I may.
Thank you.
That is certainly, I think, something that we could clarify with guidance too. If this is something that you're having already completed in the municipal process. And especially if
Meaning the municipal process to get the initial.
Yes, and if the Massachusetts Chiefs of Police Association is willing to work with us to kind of create that kind of standard template form and a list of what they'd like to see, then maybe that's something that also helps municipalities in their process. And it can be good for us and good for municipalities, but that's certainly a policy decision for the board.
Thank you, Executive Director.
Thank you, Madam Chair. I think those are great points and summarizing. So I think one of the things, just to also use the Detroit example here, is because some of these locations, again, some of them are locations that, maybe the public safety team and the CCC want to see physically in advance. In the example of Detroit, right, it was an active parking lot. So they met the public safety folks with the city of Detroit, folks in the state of Michigan. They reviewed the plans, and then Michigan and Detroit both went there the day of to make sure that it met the plans, but they didn't go to the site in advance. So I think obviously and then as well, the other thing I'd point out here, which I think is why we want to make sure that we do ensure that whatever the briefing is meets the municipal needs and our needs and doesn't need to be duplicated, is that a lot of what that clarity was between the state and the municipality is stating that the municipality has expectations above and beyond what the state's expectations were, right? So the municipality required additional security, to your earlier point about access to the exterior fence, right? Whereas the state of Michigan was only concerned that at the point of entry and the point of exit, that there was going to be at least one security guard. But the municipal plan was different. So it was setting up what is the municipal expectation. The state understands that. The state's not enforcing it. The municipality is. The state is explaining what their needs are, and the municipality is understanding that within their plan as well, and building something that is at least that, if not higher. So I just wanted to add that the equation here, that in some of these instances, where somebody's adding an event into a space that can be seen because it's meant to be an event space, it might be that a briefing would be held on site. For other situations, a lot of these would be basically reviewing what the municipality has approved for an event space, what the CCC has approved, and it might be even just a remote meeting, which then does require that follow-up. If anything changes, we need to get back together. So I just wanted to give that example. Thank you.
Attorney Gooden, I saw you coming up. Are you thinking about opining about something?
We did have some questions, if we could.
Please.
These are very quick questions.
Commissioner Webb.
When you were in language, was there a time certain on this requirement?
Madam Chair, if I may.
Please, thank you.
In speaking with the Massachusetts Chiefs of Police Association, they clarified that they would like this, they're thinking in terms of larger events and things like that. They're hoping that they have that at least 30 days in advance, but when speaking through kind of and explaining the process that the commission has for marijuana event organizers, they felt that it would be best structured and housed kind of before the event plan is submitted to the commission. And so that kind of de facto puts it in the 90 days prior to the event, and hence the additional 7-day check-in, since the public safety briefing would be submitted relatively far in advance, I guess, for, when you're thinking of check-ins close in time to the event. So that's why they have that additional 7-day final check-in.
Okay, so just so I understand.
Yes, thank you.
So the recommendation is it gets submitted with the event plan. So that gives the commission ample time to do a due diligence, cursory, whatever kind of review that the INE feels is necessary. And then as the safeguard, they revisit the plan 10 days prior to the event.
If I may, Madam Chair, they're looking more for like a confirmation. Hey, can you just let us know if anything's changed so we can make our changes accordingly? They expressed that the idea is that they'd have more involvement on the front end so that it would be much more streamlined on that second conversation. And it would, they've mentioned that it doesn't necessarily have to be, a full-on formal meeting, but something a little bit more, I guess I'll use the word casual. An email check-in or something along those lines.
But-
That's just easier.
But also, that was the question that I raised, is what is a briefing? Is it an informal? Is it a check-in? Is it a Zoom? Is it a, what I mean? I just want to make sure that we provide enough clarity that we know what they expect, because when you're, filing your, cultivation license, there is clear what the fire department has to do, clear what the fire chief has to do, clear about the amount of time they have within which they can check the box or forever hold your peace. So I don't know, and this might, well, go ahead, Attorney.
Oh, sorry, Madam Chair. Just to further clarify what the Chiefs of Police Association expressed is that, to me, what I'm hearing from them is they're just hoping to have a conversation, whether it's, I didn't get any feedback that it has, that they're looking for something in person or something super formal of that nature.
But I'm just saying, I don't want to leave that up to, I want to have clarity so that you might have a police chief who's absolutely opposed to this, right? And I'm sure this, but I'm going to slow it down. I'm going to drag it out. I don't have any time frame within which I have to do it. I'm going to tell you that it has to be an in-person meeting, and then all of a sudden it becomes an impossibility. Again, this is not casting aspersions on anybody, but just making sure that everyone, regardless of, the hat that people wear, that we're not allowing any sort of disparate access to the process based on who's sitting in a particular town or city. So whatever we can do to provide I said this in the beginning, what's briefing? What is, you know what I mean? So I don't know if there's any language that we could add or to say, doesn't have to be in person, doesn't have to be, again, this could be the checkoff box, but the clearer we can be, the better. And maybe, I don't know, Attorney Good, do you have a question or want to weigh in on this?
Yeah, thank you, Madam Chair. And but I think a lot of the questions that the Investigations and Enforcement Department had are kind of being discussed right now. So honestly, that's a little encouraging to us because we're having similar kinds of thought processes as the board here. So just a few pieces that we did want to inquire to just get a little bit more clarity. We were also wondering what exactly does the summary entail? I think we do have an interest in trying to get uniform submissions to the extent possible. Particularly thinking about, in a past experience of mine, I assisted clients with getting event permits in the city of Boston, and with their tourism department, they would host briefings that seem similar to this with fire, EMS, police, ISD, et cetera, so that they could actually speak to the different municipal requirements. That seems to be what we are looking for here, but just for clarity internally as well as for applicants here, understanding what the summary entails. Does this need to be one briefing where all of these different stakeholders are present, or can they be separate?
Email or
an email, anything along those lines. And in addition to just also wondering, how long do these, or to what extent do these public safety briefings potentially extend to multiple temporary events as well? So just reading the language here, and perhaps I'm reading this a little too narrowly, but a marijuana event organizer has to submit an event plan no later than 90 days in advance of a planned date of a temporary consumption event. So per the definitions, a temporary consumption event is a single day event. If they do have multiple temporary consumption events all lined up, so they're holding 5 consecutive days, I would imagine that would be one briefing to account for the 5-day event. However, just how this is written, we would want to make sure that we're getting clarity for our licensing team, for our investigations team, and then for my team too, if there's any enforcement issues that we need to actually prosecute after the fact. Did the licensee comply with the regulatory requirement as written? Did they provide us all of the information in advance? Did they communicate effectively with the host community to ensure that all of their questions were understood or answered, and any of those conditions that the regulation speaks to were actually implemented and complied with? So all of those pieces. We also did have a question about kind of 90 days before the event. What if things change? I do know that pursuant to our regulations under 500, 104, I believe it's sub 5, any application requirements or any submission of an application, if there are changes to the information submitted to us, a licensee has an obligation to update us within 5 business days. So if, to Attorney Bruno's point, or her conversations with local police officers, municipal officials, if there is a check-in a week before and there were any changes to that, I think the 5-day notice requirement that we have might be insufficient, just because then we would theoretically be getting the follow-up check-in either the day of, if we're talking about 2 days from a weekend, 5 business days, or 2 days in advance, which might present a difficulty for our investigations team if we're going out to the actual event, ensuring there is compliance there. So just would want to, similar to what the board is expressing right now, clarify some of those expectations, just so that we have consistency internally and we are kind of getting consistent submissions as well. And I definitely defer over to my colleagues too, if there's anything additional.
Directors, thank you.
No, thank you, Madam Chair. Build on Enforcement Counsel's point. One additional question I was hoping for some clarity is in that subsection 5, that last sentence. So the marijuana event organizer shall document the day of the briefing, names, titles, and any recommendations or conditions provided by local authorities. Asking legals, is there any intention, so once these recommendations or additional conditions are provided, was there any idea of having this plan then contain the licensee's response to those. I'm just wondering at that point, if this is all happening in unison with the permit process, maybe that'll play out itself. But if we do find that at the pre-event public safety briefing, additional conditions or additional concerns are raised, would this summary that we are expecting of them also expecting to have direct responses to those additional conditions by local authorities? Or how would those be handled if not in that summary document itself?
Attorney Bruno?
Thank you, Madam Chair. And thank you. Oh, sorry, the microphone still wasn't on. My understanding is that from my conversation with Executive Director Chief Bradley and the General Counsel was that they're really looking for the marijuana event organizer to adopt and comply with whatever those recommendations or conditions that are made, whether that be by law enforcement, fire, or emergency medical services. And so I don't know that there necessarily has to be, I mean, certainly a policy consideration for the board if there needs to be a response, but my understanding is that if there are those recommendations or conditions, that would be essentially part of what those agencies are requiring for safety purposes, essentially.
So Attorney Schroepfer, go ahead.
Also just a consideration for when we were in the working group discussing these event plans. Some of this is also just to make sure that we aren't stepping on each other's toes. It's generally understood that local law enforcement, fire, emergency medical services and everything, we don't want to do their job and they probably don't want us doing their job either. But we want to kind of make sure that it's clear who's handling what. And if they submit let's say a security plan and we look it over and we're like, whoa, hang on, this completely violates our limited access areas. Like these things are in conflict. We need to know about it and we can communicate with the correct parties. But we want to make sure that it's clear where our responsibility begins and ends around the plant, around the product, and where it's, hey, municipal police department, this is something you guys wanted. That's your show. We're not going to be terribly concerned about it. If there is a violation, if you find one and tell us about it, I believe we have another section of our regs that any violation of the laws of the Commonwealth is a violation under our regs. Like if you already found one and you tell us about it, all right, we'll also go under that section. But my understanding from the working group was this is just to make sure that we don't step on each other's toes or overlap where we shouldn't be.
So I'm going to bring it back. So I don't want to leave too much up to, I think that you and I are thinking along the same lines, Attorney Good. So is there a way that you could maybe craft and it could be including, but how would we create the nub of a template that we provide to in the regulation, noting that it's probably going to get worked out in guidance, but I don't want to leave it all to guidance because I just want to make sure. I mean, we're talking about being in the city of Boston. I ran the Girl Scouts and I wanted to do an event with 75 girls who would listen to Radio Disney and get a free Cabbage Patch Kid, and they turned down my license. And so then I had to go back and it's like, how are you not going to let 75 girls get a Cabbage Patch doll? So there are, we know what happens within municipal bureaucracies. So what I want to do is just make sure that it's clear and that we're providing not just guidance, but we have whatever that nub might be. If you could give that some thought and maybe share that. And I don't know if you're comfortable with something like that, Commissioner Stebbins, but I think that if we get something, it doesn't have to be totally drafted, but something there.
Madam Chair, if I may, we can certainly work on that offline and bring that back for the 11/7 meeting.
Yeah. Are you comfortable?
I guess I'm a little confused.
Okay.
So you are proposing to strike this in its entirety and move it to guidance?
No.
Oh, okay.
No, not at all. What I'm saying is that I initially raised the issue of what is briefing.
Right,
And
right.
how how do they check the box? And all I would like is, what is sufficient? We were just saying, do they have to all be in the same room? Do they have to do a site visit? You know, maybe they do, maybe the city says, we have this, we absolutely want to mandate, you know, but all I want is something that we can hold them to that also is helpful to the applicants who can say, this is going to happen, this is going to happen, this is going to happen. And then we know what the municipality requires. We know what the licensees have to do. And then we get enough advance notice as to what that check the box is. But obviously that's too much to just stick in here. So if there's any way you can work with the team to help create a note that says, we want to give you the authority to do it locally, but we want it to be transparent and we want it to be a checklist that applicants have transparency on. I don't know if I'm saying that the right way, but I think that's what I heard you say. And I don't think it has to be totally laid out, but something that says it's got to be clear and it's got to be time efficient and it's got to be responsive. So, does that work? Does that work for you, Commissioner Stebbins?
Yeah, and I think some of this might find its way into guidance, right? Which is a document we can more easily update than going through regs, but I hear you.
Commissioner Roy?
Yeah, 500-101. In 9, we talk about documentation that the applicant has conducted a community outreach meeting.
Right.
Consistent with the commission's guidance for licensed applicants on community outreach within 6 months prior to the application. So
in that, it literally says you have to have a translator.
So right. So maybe we lift from this and point to that. Does that make sense?
I think it might.
Okay. Okay.
Okay. Thank you. Okay, Attorney Bruno. So, let us sort of maybe, I don't think anybody really has a hard stop, but let us aim to finish at 4:30. Does that make sense for everybody? I don't know if anybody else needs to. I don't know if we need any quick breaks. I think we're all living still, so.
Breathing.
Okay, we're breathing, so we're on it. Okay. Attorney Bruno.
Thank you.
Thank you. Thank you.
Chair.
Thank you. That was good. I'm already finished today.
We will move to page 34 at 500-050-6M3W is what we will be looking at. This reads, for sales conducted at a temporary consumption event, community impact fees authorized pursuant to Massachusetts General Laws, Chapter 94G, Section 3D, and any applicable marijuana local tax option amount due on marijuana or marijuana products pursuant to Massachusetts General Laws, Chapter 64N, shall be allocated to the host community of the marijuana establishment that conducts this sale. Community impact fees shall be remitted consistent with the terms of the consistent with the terms of that host community agreement of the marijuana establishment that conducts the sale. The Massachusetts sales tax and marijuana excise tax shall remain payable to the Commonwealth in accordance with Massachusetts General Laws, Chapter 64H and Massachusetts General Laws, Chapter 64N, respectively. And specifically, this is new language in response to public comment in regards to marijuana event organizers having an HCA for each and every town and city that they would have an event, a temporary consumption event. We did consult the Department of Revenue. What they have advised to us is that there can only be one host community agreement per licensee for the business. And so this was the language that they suggested to clarify any confusion that there might be as to host communities. There can be only the one per licensee.
And then this also leaves the opportunity for municipalities to, on the local level, charge fees or other things like that. So they can certainly, when they do something like this, they can generate revenues from that or diminish any of the impact on the community. Commissioner Stebbins, any question?
No, just a comment. I think you clarified it, Chair. It was, and who are we to argue with you are, but this is meant to imply that wherever marijuana event organizers' principal place of business is, that's where their HCA is.
Sure, any question?
No, I just was thinking, well, not directly related, but so I know with the hospitality that let's say I own the yoga studio and Shannon's Cannabis wants to hold an event. And so I can't get a percent of her proceeds, but I can charge her rent for the space. Now, what if there's a charge at the door, cover charge, if you will? Have we contemplated like ticket sales, cover charges? Have we thought about that?
Can we do
Is that permissible? Is it not?
Can we,
I
can you, rather than,
percent of the proceeds, it's just an entrance fee. Can I, as a landlord, get a part of that?
Okay, I'm sorry, Madam Chair, if I may, that helped clarify your question. If the non-cannabis, you're asking if the non-cannabis entity can obtain part of the proceeds
Of an entrance fee.
of the entrance fee. I'm sorry, Attorney Scheffler, did you?
I think that could be a scenario that could happen.
So one of the things that was, when we discussed some of these things in a working group, the issue that we were thinking on along the lines of is don't let the streams can't cross. So like especially with tax questions on the sale of marijuana or marijuana products, it's access to the building. That's not the sale of a marijuana or marijuana product. So it's not really our concern. When you enter in there and you buy your pre-roll or you buy your edible or whatever, that's where our concern is, our concern is triggered. So to answer your question, as long as you aren't commingling those funds, you're okay.
sure,
Yes, but I can see a scenario where you buy this ticket in advance and it entitles you to a free pre-roll.
It's a shame enforcement council isn't here anymore because that sounds an awful lot.
Right there.
I'm still here.
We yell Tim or Paul into the microphone and get you back.
But that it rings it rings a bell in my head, like that would be some sort of invalid promotion. But
he's up here, he's right here. There we go. Can you restate, reframe and request? Oh, I thought you had a question.
Based on my question.
Based on her question. Can you, so what you were saying is, is it okay to charge a fee and then give you? Yes.
Yeah, so
Isn't that how people were getting away with some things, is they were?
that's how they do it in DC right now, I believe. So this schema exists in the world. I'm not like making this up.
I believe the hypothetical was where you have an event, you're charging a cover charge to enter, like, I don't know, see a comedian or something. And along with that ticket price comes like a coupon or something for a free pre-roll at the social consumption establishment. It just rang a bell in my head, but I wanted to make sure run it by EC on that front. That's your wheelhouse.
Okay. Thank you. Well, and it is interesting because everybody is using the magic words here. So under 94G section 4, subsection A.5, clause 29 or Romanet 29, it's related to requirements for advertising, and the statute specifically requires that we have a provision that prohibits advertising, marketing, and branding through certain identified promotional items as determined by the commission, but including giveaways, coupons, free or donated marijuana. So based on my analysis here, based on the conversation here, based on my understanding of the statute, based on my understanding of our regulations, which I believe are contained in 1054B20, but don't quote me on the exact citation there. But we have mirrored this language and then have gone beyond that in some other prohibitions on certain advertising. So if somebody was saying, hey, buy a ticket, and with this ticket, you get a free product.
Well, it's paid for with so that ticket price, you've paid for the pre-roll.
Includes a pre-roll.
Includes
Okay,
a
so that would be, I guess, a little bit different.
That's a little loophole.
Free marijuana product with admission or something along those lines. But I just, based on the statute, based on our regulations.
Sorry, I just dropped out. Second, I just dropped. We're still having teams. Running teams.
Your microphone.
Okay, sorry, it keeps dropping. Sorry about that.
Okay, so I guess it's $20 ticket, but part of that is you paid for a pre-roll. And I guess that's feels like could be a loophole, number one. And number two is there is that now streams are intersecting here where does that revenue get reported?
Understood. So the question here, and looking at the language that's up on the screen as well, we're talking about more so kind of for DOR purposes, for tax purposes, making sure that the sales tax for the marijuana product is actually going towards the appropriate fund and the actual local option tax. Okay. So in those circumstances, I mean, I think that's primarily a question for DOR in terms of how those tax revenues are actually allocated and how those are collected in that sense. Based on the language here, it appears that what we are trying to do with this language is to ensure that circumstances like that are accounted for. So if a licensee is unable to appropriately collect and remit those sales taxes, I do think that would be primarily an issue with DOR. If there are issues with DOR, for example, if a licensee is unable to get a certificate of good standing or a certificate of tax compliance, if they're engaged in a payment plan or something along those lines, then that does have downstream effects for us in terms of their license renewal. It may create an enforcement action or lead to something along those lines too, if it becomes a more persistent issue. But I think the first agency that is going to take issue with that would be the Department of Revenue before us, because we are not specifically collecting those sales taxes.
And I just will say, I'm dropping out of, I keep dropping out of, I should back in. I don't want to, I hope this doesn't reverb again.
Madam Chair.
Yeah. Sorry, just, right, at First Attorney Shuffler, I think you had it. At First Attorney Shuffler, I think you had it. It just keeps dropping out.
So I wanted to just point out one area where the regulations kind of start addressing this on themselves. One, a marijuana establishment outside of marijuana products and things we specifically authorize can't sell things that are not marijuana or marijuana products unless that you specifically get permission from us or is otherwise provided for. So like an event ticket, that would be you're selling something outside of that. So the hospitality establishment inside is most likely not the one selling the ticket. So if the one selling the ticket, which in this hypothetical also includes marijuana, that would be sold by the hosting agency, which would be an unlawful sale of marijuana by a non-licensee. So like these by kind of legal necessity and by tax necessity kind of have to occupy separate streams. You couldn't collapse the two into one without it triggering a problem either under our regulations or under you're not a licensed marijuana establishment. What are you doing selling marijuana?
Attorney Bruno? Go ahead.
Thank you, Madam
And I
Chair.
just will say, I keep dropping out. So I think I'm back on right now, but I mean, we're rolling, we're gonna wrap up in a
Keep
minute.
going. I'm grabbing a sweater. You guys keep going.
Okay, all
Right.
right. Thanks. Okay, Attorney.
Sure. And this is on the issue, and I'll repeat it for Commissioner Roy when she returns, but I'm sorry, I keep forgetting to turn on my mic. This is on the issue of the sales of the tickets and her question specifically as to, who gets the sales? Can there be a portion of the ticket sales split to the non-cannabis entity? So this is under 050, 500-0509, which is limitations on the number and control of social consumption establishments. Under B, which reads a hospitality on-site consumption licensee and a marijuana event organizer licensee shall not, Roman 2, provide a set percentage or a set portion of sales to the non-cannabis entity. And then it goes on to state a hospitality on-site consumption licensee and a marijuana event organizer licensee may pay a fee or rent to the non-cannabis entity for housing or hosting the social consumption establishment. And then we clarified at the last public meeting that provided, however, if they have the same persons with or entities with direct or indirect control, that's when they could share the sales or the proceeds. And so this was to your question, Commissioner Roy. I'm sorry that you had to step out for a moment. No, yes, I've been covering up my sweater too. But this is to your question, Commissioner Roy, specifically as to whether the non-cannabis entity and the marijuana event organizer, can they share the ticket sales? Our regs already say no, they can't unless they have the same persons with direct or indirect control. And so I think that goes to General Counsel Scheffler's point as well, that if it's the non-cannabis entity selling the ticket and then also trying to provide the gift of a pre-roll, that would be a violation of our statutes and regulations as well. But then additionally, on top of that, we have that clarity where they cannot be sharing the sales as well.
So the ticket price is, they're saying you've paid for the pre-roll in the ticket price.
Yes.
And so I just want to make sure like there's no loopholes here, that we've buttressed this to a point where people get creative. I've seen it.
If I may, so it would have to be the marijuana event organizer or their retailer, who's authorizing those ticket sales in order for the pre-roll joint to be the gift. Otherwise, that would be a violation. Okay. That makes sense.
Does that need to be expressly enumerated anywhere?
I think it's sufficiently covered in other locations and also as well with what Enforcement Council is pointing out is the promotion itself. That model already throws a ton of red flags on the field and may result in an enforcement action if somebody did decide to get creative.
Okay, I think that sports analogy is good.
Madam Chair, thank you. And Commissioner Roy and the board as well, just as we're talking about this too, under 500-450, which that section just generally identifies grounds for suspension, revocation, denial of a renewal application. Under 450 subsection 3, it does identify that if a marijuana establishment fails to comply with any requirements of the statute or regulations or any applicable law or regulation, including but not limited to laws and regulations of the Commonwealth relating to taxes, if this became kind of a persistent issue, or even if we're identifying this as a circumstance that we want to pay particular attention to and prosecute if necessary. We do have other avenues throughout our regulations where we could take an action if there is kind of the failure to remit certain sales taxes. If we do see, I know you've heard from the Investigations and Enforcement Department that the advertising regulations are challenging at times to actually enforce and ensure consistent application or consistent adherence to our regulations by our licensees. However, with regard to free or donated marijuana, that is a requirement that is explicitly identified in the statute as something that we need to pay attention to. So when we're talking about kind of loyalty programs, et cetera, that's not specifically articulated in the statute. Here, this is something that is, so we would hold that, or we would want to ensure that that is being upheld by our licensees, that they're not advertising that you get a free product with the purchase of this ticket, or even if we're talking about the scenario that you're saying where something is included with the purchase of a ticket, we would need to ensure that sales taxes are moving appropriately or that those funds are actually going where they're supposed to go.
And if I may, Madam Chair, so we eliminated the pennying out. So like metric, how would that look in metric if they tried to?
What did you call it?
There was an option for pennying out and it was being used creatively, let's say. And we've shut down. Since eliminated that capability, correct?
Madam Chair.
Would you just tell me what pennying out
Yeah,
is?
of course. So we actually did issue a bulletin sometime within the past year and a half or so, I believe, where we identified that pennying out as a practice. So what that entails is in metric to actually still comply with the seed to sale tracking requirements. If licensees were giving away a free joint with a purchase or free product with a purchase, they would mark it down as for a penny, sell it for a penny. So colloquially called pennying out. What we identified or what we issued in that bulletin or advised the industry rather is that under certain circumstances, pennying out might be all right because we're not setting minimum price thresholds. But what we were identifying is that in certain circumstances, pennying out could be viewed as diversion. Because there are, I know we've had instances where large amounts of product are being pennied out for purposes that are contrary to our regulations. And there are a number of matters that I can't discuss right now, but that have been brought to our attention, I'll say. So as it relates, Commissioner Roy, to your question about eliminating that in metric, I can't speak to that as I'm sitting here right now.
Right.
I
Yeah.
don't know exactly
Right.
if that has been eliminated necessarily. But the practice of pennying out does raise red flags for us, and we have been following up with certain investigative steps in those instances where we're identifying kind of a consistent or questionable practice of that going on so that we can actually ascertain what is happening here. Are they using that process for a non-compliant purpose?
Mhm.
That would require some sort of additional follow-up.
Okay. All right. We are heading towards 4:30 and
Thank you.
thank you very much. That was helpful.
Yeah.
So are we good with this language?
Yes. I just got, and I apologize, like, you got my wheels spinning in another direction around that. So,
But this is what this is for.
yeah, because we can't do it in private. We
So-
can't do it in private.
All right, so we're at 4:30 now. I think that this is, considering I keep dropping out, I can't. Getting thrown out of teams. I think that this is a good time for us to take a pause. Commissioner Stebbins, do you have anything, questions? Dick, Director, any thoughts or comments? With that, because I can't see the screen, but with that, we will be meeting again on November 6th at, November 6th at a hybrid at 10 a.m. Again, this will begin, that will be primarily the listening session regarding the disproportionately impacted areas. And then we are posting November 7th. We will be spending more time on this as well. And then looking at those additional dates to make sure that we get all of this done. But these are tentative and subject to change as always. So, Commissioner Roy?
Yeah, I just want to level set us before we adjourn. So we're still in commissioner decisions. We got through 110. We're still in 050. And we still have a lot more commissioner decisions to go through. So after the listening session, I think, right, we'll resume on
Yes,
050,
yes.
HCA, page 34, HCA at principal place of business.
Yes.
Okay, wonderful.
And it's we're gonna get it right, or as right as we can. And Attorney Bruno?
Thank you, Madam Chair. Me and the microphones today, I'm sorry. I just wanted to clarify, we did cover the page 34, so
Oh, we
we're
did.
all the way through 050. So
Okay.
we will pick up
141,
141.
wonderful,
Consumption areas.
perfect, thank you.
Great. Yes, Director.
Thank you, Madam Chair. I just want to make sure too, so November 6th, I believe that we're intending to set that up as the listening session in the morning, regular business that would have otherwise been on the 13th is the intent, but again, to your point, it's all subject to change. And then November 7th is blocked off to be Another session,
Dave's.
social consumption.
Yeah.
Great, thank you.
And the 13th is regular business licensing.
Again, we may have to
Combine.
that we can get this all wrapped up because our intent is to get this done to the Secretary of State's office and ready by the end of the year. And we think that we can meet that deadline, but again, subject to us getting this as robustly done as we can. So with that, I will entertain a motion to adjourn. Commissioner Stebbins?
So moved.
Commissioner Roy?
Second?
Having been moved and seconded, I'll call the roll. O'Brien votes yes. Roy?
Aye. Yes.
Mr. Stebbins?
Aye.
Unanimously approved. We adjourn. Thank you very much.
Thank you,
And really
everybody.
thanks, to the
Thank
whole
you
team.
so
Everybody
much.
did a great job today.
Thank you.